What's up, everybody? Potentially the most wild day in court I've ever seen. Things I've never seen happen in a trial before. The lead officer's personal text messages between he and his wife, he and his buddies, he and his supervisors, he and his coworkers blasted in front of the jury on direct examination. Cross just started. We've got Michael Proctor on the stand, but so much more. We're going to start talking about the hearing. We're going to get through all the other testimony today, and we'll, of course, end by digging into what Michael Proctor said on the stand and throughout the investigation and how it actually affects this case. Is it relevant? Is it going to make a difference at the end of the day? All that and more. Of course, we'll answer your questions. Make sure you guys hit the like button because we are jumping into it now. So today got off to an interesting start because we got to see the hearing or listen to the hearing on the document we broke down this weekend, which was the Commonwealth's motion to exclude an expert witness and potentially limit others, but at least get more discovery. By the way, I know the chat's going to be going crazy with the Young Thug trial. I saw some clips. Incredible. We'll talk about that. It's crazy what's happening in our world and our judicial system in America. My dad is looking into that as well. So I'm probably going to do a video tomorrow on that with him. So have no fear. We will talk about that. But today is going to be focused on Karen Read, obviously. And we're going to jump in with the motion that started with the Commonwealth basically reiterating what was in their motion. They're not getting things in a timely manner. You can't bring witnesses in after the trial's already started. It's not fair. But there are reasons that the defense has. And it's really interesting because one of the reasons is what we're hearing a lot in the Koberger case, that it's part of the federal investigation. We don't have control over that, Judge. We're dealing with the feds. They give us what they give us. But there was a very, very interesting exchange between Yannetti and the judge during this hearing that a lot of you guys had questions on. I was pretty shocked when I saw it. Seems like nothing based on what happened at the end of the day, but it was very important. The first thing we saw with this day, this was outside the presence of the jury, but still telling with how the judge potentially looks at this case.
So I'm going to go to the podium with the court's permission. We need to be heard on this.
That's why we're here, Mr. Yannetti.
Thank you. I'd like to start.
So sometimes lawyers, and I've noticed it with Yannetti and Jackson, they kind of have like tics. He's like, we need to be heard on this, Judge. He wasn't playing for the cameras right there. And he was just saying it like, we need to be heard, and here we go. And she's like, yeah, that's why we're here, Mr. Yannetti. Frankly, wasting time with, additional words she didn't need to, but that's the least of it.
The most outrageous and false assertion that the Commonwealth made in its motion.
Can I just ask you, there's no jury here. Can I just ask you how long this is going to take?
Between 5 and 10 minutes.
Okay. Because I don't need, the hyper.
5 and 10 minutes in almost anything you do in the law is not ever going to be looked at as, no way, you cannot take 5 to 10 minutes, sir, making this argument. Like, that is nothing. Lawyers can't introduce themselves in 5 to 10 minutes. And she's like, oh, there's no jury here. It's like, whether there's a jury here or not, he's got to make a record. Now, do these lawyers have a bit of hyperbole? Do they put on a little bit? Do they like the show? Obviously, they like the show. So I get it. And I get telling her to relax. There's no camera, or there is cameras. To relax, there's no jury. I get that. But he's obviously got to make the record. And what he says is pretty shocking to me about what the Commonwealth did, and her response was frustrating, to say the least.
I need to make my argument in the way that I think is most effective for my client. I will keep this brief and succinct, but I have points to make that I need to put on record.
Okay, and I'm the person you are trying to convince, correct?
I understand that. The Commonwealth, in a public filing, wrote the following on page 3 of its motion. Quote, during a pretrial hearing on February 15th, when asked by the court whether there was any dispute about a canine's involvement or canine DNA, Attorney Yannetti indicated no, and that the defense was not pursuing such claim. I was astounded to read that for 2 reasons. First of all, it is—
So was I. So was I. Again, I didn't know what happened, so I was like, okay, I'll give the Commonwealth the benefit of the doubt. But then when he argued it in the opening statement, why didn't they object? Because if that was part of the judge's prior ruling and he already agreed not to argue that, they could have objected. Bev would have sustained it. She would have stricken that argument. And then not only did they not object, but then they elicited testimony from an expert about canine DNA. So it was very surprising. I was like, well, the door was open, so they can argue it now. Turns out, according to Yannetti, that's not true. He never said it. Does he have receipts?
False. It is a lie. Second, the Commonwealth has knowingly lied about something where it's easily verifiable that they lied. We pulled the tape from February 15th.
I don't have that.
I'm sorry?
I don't have that in my motion.
It's on page 3, Your Honor.
I have the Commonwealth's renewed motion for reciprocal discovery, a motion to exclude defendant's expert, Dr. Marie Russell. I don't see your name at all, Mr. Yannetti.
Oh, this was definitely in there. We read it.
I'm on page 3.
Sorry, it's not page 3, it's page 4. My apologies.
It may have said the defense attorney. I don't remember if it said the defense attorney or Yannetti, but they definitely said he abandoned that argument or said he wasn't going to argue it.
My name is right there on page 4. It says exactly what I just argued to the court. It's about the 5th line down. It starts during a final pretrial hearing on February 15th, exactly
Okay.
as I said.
Okay.
All right. We pulled the tape from that February 15th hearing. Here is what was actually said. This court asked me the following, quote, while we're talking about DNA, Mr. Yannetti, do we need to be concerned about canine DNA? Where do we stand with that? I replied, no, I think this is the only outstanding DNA issue. The court then replied, okay, so all right, we're not dealing with canine DNA. And I said, no. There is nothing in there, contrary to what the Commonwealth has represented to this court in a public filing, that I said there was no canine involvement. There is nothing in there, contrary to what the canine represented to this court and to the public, that the defense was not pursuing such a claim.
So, you know, they make sure to know that it was a public document, that they made this statement to the public, and that it was a lie, not true. And the reason he said it's easily verifiable that what they said was incorrect is those are some of the steps towards bad faith or potential ethics claims or problems or complaints made about attorneys writing falsities in public documents. Now, you can make mistakes. There can be scrivener's errors. There can be issues. But if you knew or should have known, and how can you prove should have known, it's easily verifiable by the tape or the transcript of that hearing, then that's bad news. I have literally seen judges sanction lawyers for this exact behavior, So let's listen to how Judge Bev handles it. Thank you, Rebecca and Tina K.S. Launard, for gifting a bunch of memberships today.
Can you imagine the nerve of the Commonwealth to spend that?
This is the hyperbole I don't need. Could you please get to the point?
We've
got a jury coming in 15 minutes.
I understand, but this is
just FYI. I've had not quite this bad, but things like this happen in cases. And I'll throw some hyperbole into a motion that a jury will never read, that the judge will read, because I want the judge to know I'm pissed. I want the judge to know she needs to do something about this. And I also, usually one of the reasons I do it is I lay the foundation for future motions and future issues. So if the lawyers continue to do this, I've gotten sanctions against big law firms for this exact behavior. I shouldn't say this exact behavior. It's not even this bad. But when they do it 2, 3, 4, 5 times. So when you make a clean record and you make sure the judge knows you're pissed, and then they do it again, the judge is like, all right, that's it. That's it. We're sanctioning you now. So sometimes we lawyers make hyperbole to judges. Sure, we make those kind of arguments. And Robin Knoll said, Peter, do you think the defense is making a good show for the Netflix documentary? I absolutely believe there is an element of that in this case. I absolutely believe that people know there are cameras, and the defense and maybe even the defendant and a lot of other people potentially are involved in this, and they know that Netflix is going to do something on this, or some streaming service is going to do something on this. There will be documentaries. There will be made-for-TV movies about this, no doubt about it. So there's absolutely an element of that. The judge probably doesn't like it. Most judges don't. So she's trying to calm that down, and I get it. And the hyperbole comment doesn't bother me as much as trying to rush him through it or making him move on when he has a legitimate gripe and a legitimate argument to make.
My integrity has been attacked. There have been allegations of bad faith that has been attacked, and I need to defend myself and my client. We were only discussing at that time whether canine DNA was still outstanding, and I succinctly replied, no. And they've spun that, or tried to spin that, into a claim that we're somehow waiving our right to argue that John O'Keefe's arm injuries were consistent with a dog attack. And I ask you, have they no shame? I'm sure it's not lost on this court that this false filing by the Commonwealth comes on the heels of their nefarious attempt to pass off an inverted video, a false video.
I mean, you can literally hear her sighing in the microphone when he's complaining about an absolutely legitimate problem that an officer of the court lied in a court document because they knew or should have known that fact was absolutely false. They knew how they were using it. They made the argument. For somebody like me that did not see that hearing, did not listen to that hearing, I absolutely came away from their document and their filing thinking that Yannetti said he was not going to make the dog argument. And then he did it in opening statement. So for that to be false, the judge should absolutely care about that. And she should just give a talking to the Commonwealth outside the presence of the jury, of course. But holy cow, she should absolutely give a talking to the Commonwealth after this.
Or this good jury hearing this case. Never once during the direct examination of Sergeant Buchanan did they inquire or mention the fact that the video.
Can we please, all right, I'm going to stop you. Please direct your comments to Rule 14 and the reciprocal discovery obligations that the defense has. That's what this motion is. I know you have a speech you want to make, Mr.
It's
Yannetti.
not Your Honor, it's most respectfully, it's not a speech. It's
Okay,
a defense of being alleged to have committed bad faith.
So you've moved on from that. So please just focus on Rule 14 and let's do it in two separate parts. So you've changed, you're not calling Frank Sheridan,
No,
right?
we are calling Frank Sheridan.
All right. So you've got a new medical, Dr. Russell. We'll do that part of it separately. Tell me about what you've provided the Commonwealth on Chris Van E.
They've gotten his CV and they've gotten the substance of his opinion from us. And they've had that for a long time. And the court, I believe.
They go back and forth a little bit on what they do have, what they don't have, when they turned it over. We're going to skip ahead a little bit to hear what the judge has to say about it.
What his opinion is. All right, by the close of business tomorrow.
That's fine.
All right. Now, regarding the 3 experts from ARCCA. So I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided?
Your Honor, we've provided everything that we know. We've mentioned to this court at sidebar, these experts did not arise from us.
I understand that.
These experts were hired by the federal government and they provided a report to.
Therefore, that provides some issues with disclosures and what they know and what they don't know. Just like I say, you got to give the state the benefit of the doubt in Koberger because the FBI is probably not turning certain things over to them. Same thing here with the defense. If the FBI is not turning things over to them, then they don't have it. And they can only turn over what they have, right?
Us pursuant to the TUI request. And it was specifically outlined that and ruled that they could not prep with us.
So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here
that's essentially, we've spoken to them only for the purposes of coordination of their testimony and their background. That's it. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
See, I don't see that as being, the report, I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify to.
Well,
and you have not complied with your Rule 14 obligations.
You can't, Your Honor.
So you can't, but you haven't. So I am left with you haven't complied. So we need to get everybody here for voir dire. They can testify in voir dire, right?
And that's the point. We solve this problem completely if we do the voir dire. Bring the witness, ask them the questions, and let's move on. Let's not act like the defense is doing something wrong here by not providing something they don't have, okay? Now, if they can't produce the witness for voir dire, if they can't produce the witness to explain what they're going to testify to, and the judge can make her call and daubert them and see if they're an expert and see if they're appropriate and see if they can actually testify to some expertise that's going to aid in the jury in understanding something here, well, then they don't get to call them. It's frankly a waste of time to have a lot of these arguments when we all kind of knew how this was going to end. And if you go back and listen to my recap this weekend, this was always the right decision and the most likely decision. And that's what the judge ended up doing. Now the mic is going to cut out here in a minute, but we'll listen to the next 2 minutes.
We need to do that well in advance of their testimony.
Okay, that's fine, Your Honor.
All right.
Yep.
And now tell me about this ER doc. Is she an ER doc? I haven't seen her. She's not a pathologist,
Well,
correct?
she's a pathologist, but she has a lot of experience in an ER, which is why she has the experience of having seen dog scratches and dog bites and dog attacks.
All right. So this is not somebody that was involved in the federal investigation, correct?
Correct.
All right. So you need to provide immediately. I want a voir dire of her this week. So we can get her here Wednesday. And we want the other folks up here from Pennsylvania this week as well.
We'll make those calls.
So we need to pick a day. How long do you expect the voir dire of each of these witnesses? If in fact the defense has not spoken to these witnesses from Pennsylvania about the nature of their opinion, you must want it too, to be able to question them. How long do you expect the voir dire of each of the witnesses to take? I went and told the jury last week, last week that we were going to get them this case by the end of the month based on your representations, which included voir dires. It looks like at least a day of voir dire hearings here.
Yeah.
Yes.
At least with regard to the of course, at least with regard to the ARCA witnesses, that's my co-counsel's bailiwick. He anticipates that unless there are a substantial number of objections during the voir dire, he anticipates being able to accomplish that between 45 minutes to an hour with each of those 3. With regard to Dr. Russell, we anticipate a half hour. Oh, sorry, only 2 from ARCA, that's right.
You're only calling 2? Which 2? Are you calling the 2 that are certified as accident reconstructionists?
Doctors Richler and Wolf. Yes.
So the mic cuts out, but generally speaking, it sounds like she's saying exactly what she should. They've got to provide the information. They've got to provide the documentation. They've got to bring them here to be voir dired so that we can see what they're going to testify to, see if they're qualified as experts. The judge will make the call, and that's it. no major discovery violation, no bad faith. She didn't find any of that, regardless of what it sounded like and the allegations the Commonwealth made. Now, let me hit a couple of these questions because they're all pretty similar. Do judges care about the way they come across? Usually elected judges do. I believe she's elected as a state judge. Federal judges that are appointed for life usually care a little bit less. Maureen Scott, Peter, can the defense file anything regarding the judge's behavior minding? And I'm not trying to, dodge stuff, but I haven't watched all of the prior hearings. So I don't know how she's treating the defense. It's annoying. It's frustrating. Lots of judges do this to defense attorneys, especially private defense attorneys that fight tooth and nail. Judges get annoyed. It happens all the time. I see it with my dad. My dad goes at it with judges. And we've had trials where he and I are up there fighting with judges, voir direing expert witnesses, not understanding how certain things can come in. It's stacked against you, whether you like it or not or believe it or not. That's what defense attorneys are up against and fighting against. Rebecca said, what's sad is that I smell appellate issues. Hold on. Is that I smell appellate issues. And I would say right here with this, I don't think there is an appellate issue because I think the judge ended up making the right decision, even if the way she did it was kind of annoying. Tons of questions coming in. I'm going to get through as absolutely many of these questions as I can as we continue to go through, but I want to make sure we get through all of the, John said there was an issue, so I'm just checking to make sure it's fine. All right. It sounds like it's fine. Okay. So then we get to the cross of Yuri continued. He again wasn't sure which one was him and which one was Proctor, even though he specifically said it on direct. And Jackson, referenced exactly when you use your pointer to say, this is you, this is Proctor. It was very confusing. Talks again. He kind of reiterates a lot of things about the mirrored video. He uses a tattoo on your left arm. If you're looking in the mirror, it looks like your right arm, kind of like what we talked about with the wedding ring. He talked about how there's a bunch of time missing on the video. Yuri kind of talks about how it's on motion sensor, so that explains some of it. But what I keep thinking is when the car comes in, wouldn't that spark the motion sensor? And again, more on that coming in redirect. It does seem like someone appears out of nowhere. The defense has another flash drive. There's another sidebar. And eventually we get to see what's on this flash drive, which is different than the other flash drive. And it ends up being the corrected video. And I think the main reason for the defense doing this was just to show the jury how easy it was to flip this video and how the state easily could have done it, but they didn't. So the defense had to show the jury what it looks like with the actual appropriate view.
To a runtime of 1 minute and 17 seconds. So fair enough. And go ahead and pause that. Sergeant, do you recognize what's depicted in what's just been marked as Exhibit 542?
I do.
How do you recognize that?
It's an inversion of the video provided from Ken Beatty, Sally Point.
It's actually, and that inversion corrects the perspective. Would you agree with that?
I would.
Okay, so now we're looking at what we've always been looking at.
You just agreed that this version corrects the perspective, which would mean the first way was not the correct perspective, or also known as the incorrect perspective. Now, I'm mincing and picking apart words, but that's what he just agreed to.
It's clear from the driver's side of the vehicle, correct?
That's correct.
And everything is properly oriented, is that right?
It's an accurate depiction of what is taking place.
Meaning right is right and left is left in this video.
The vehicle came from the right into the left. The driver's side is visible and is closest to the camera.
Go ahead. Thank you, sir. You can go ahead and finish. Just a few seconds, please. Pause it. You saw the person that was toward the back of the vehicle that you earlier on Wednesday identified as Proctor moving toward the right. I'm sorry. Yes, the passenger side taillight area in this video, correct?
I observed the person walking that way.
Let's go ahead. Awesome. And you see the person toward the taillight area moving out of frame just now, correct?
I did, yes.
That person had the that black portfolio in his hand.
That's correct.
I'd like to ask Mr. Bates if you wouldn't mind moving the cursor back to the beginning before the video, before the SUV was actually in the Sally Port. We can pause that. Do you see what's depicted in the video now at one time at the beginning of the video?
I see the still frame. I'm observing the still frame.
Okay, fair enough, fair enough. Can you see from where you are, sir, can you see the chyron at the bottom of the video in blue, indicating the date stamp and time stamp? You see that from where you are?
I see the blue color. I don't know what exactly it is.
Are your eyes good enough to see that that is completely inverted?
They are not.
They're not inverted?
They are not good enough.
That was a good answer to that question on my part. With the court's permission,
All right. So basically, they get to the point where the video definitely jumps around. On redirect, Lally gets up and has Yuri confirm he didn't alter or manipulate the video. Lack of motion basically had a lot to do with that. And he also asks if snow fell off of John O'Keefe's car in the Ring doorbell video at John O'Keefe's house. He wanted to, we watched it in slow-mo. He basically said he didn't remember. And I bring that up because if he would have remembered, I think it would have been really weird that he remembered that one detail, but he said he didn't remember, which I found to be more credible. But then they get into the smashed taillight and how Yuri describes that.
Sir, the Ring video 153 from Exhibit 6 at 5:07 in the morning at Mr. O'Keefe's house when you can see the defendant's smashed taillight.
objection.
So the objection sustained. Ask the question.
5:30 p.m. on January 29th. Is that before or after 5:07 a.m. When you observed the defendant's vehicle on the Ring video at Mr. O'Keefe's house?
That is after.
Is that before or after you observed on the Ring video the defendant, Ms. Roberts, and Ms. McCabe driving the defendant's vehicle and parking it in the driveway of Mr. O'Keefe's house?
It's after.
And is it before or after about, say, 8:22 in the morning, at some point when a Canton Cruiser parks in the driveway behind the defendant's vehicle?
It's after.
And is it before or after about 12:30 p.m. or so when the defendant and her father and her brother from the videos from Exhibit 6, the Ring videos on One Meadows Ave, are parked in and around the defendant's vehicle and then leave with the defendant's vehicle to go to death?
It's after.
And is it before or after the video that you testified about on Wednesday in regard to the surveillance video from the defendant's father's house in Dayton when that vehicle was being loaded onto the truck and you can see the taillight there?
John.
It's after.
Now, again, you had a conversation or an interview with the defendant on the afternoon of January 29th when you were in Dayton, correct?
That's correct.
And during the course of that interview, she made statements about her broken taillight and when that occurred, correct?
Objection.
Do you want the instruction, or do you want to come see me at sidebar?
So they go to sidebar, and we're going to come back because you see some, arguing here and some objections and things the defense doesn't want to come in. And this was, because we're going to get into some more judge questions because I see a bunch of people having problems with the judge, and I get it. And I'm going to get to this comment after, but I'll just get to it now. Peter, you can't think the judge is acting normally toward the defense. Prosecution has already gone on 22 days. Defense may have a week total. Something's wrong here. So first off, I'm with you on some of it, but the defense has requested a week. They have told the judge it's only going to take them 4 days for their case. The judge has not limited them to that. I'm pretty sure, could be wrong, but I'm pretty sure if the defense said they had 2 weeks, the judge would have given it to them because the defense is entitled to as much time as the prosecution takes, and they would have just had to set it on a larger trial docket. But if the defense only requests a week, the judge is within her right to limit them to what they requested, but for new evidence or in the interest of justice, extending that. Okay. Number two, I have been a part of and watched lots of trials. The judge is usually harder on the defense. Now, this case, there is definitely some worse than average behavior for the judge toward the defense. I absolutely agree with you. And I'm going to highlight it here in this ruling that the judge makes, which is just horrendous and would have me falling out of my chair if I heard a judge say this.
That is correct.
And can you explain to the jury what led to that statement as far as what you knew at that time and why you would make those statements to the medical examiner?
The Master's General Law directs us, just as it gives the district attorney's power to and authority over all death investigations. That's the following section 4 of that chapter. Following section from section 4, section 5 of that chapter directs all state medical and police entities to work in coordination with the medical examiner's office. By law, we're supposed to work together on the medical legal investigations that the medical examiner's office conducts. We conduct the criminal portion of the investigation. They conduct the medical portion of the investigation. Thus, I contacted.
This was him kind of getting into why he made the statements to the medical examiner. and why it was important they talk, not because he was going to doctor the report or anything like that. Becomes really important later when we get to Proctor's texts. But for this, the most important part is what the judge does with this objection coming from the defense.
To the medical examiner's office and advised them that what we had learned at the time. Up to that point, we had learned that the defendant stated that she hit him. We had collected, meaning the Canton Police Department had collected a broken glass. So based on the physical evidence and the statements made by the defendant to the first responders at the scene at that point in time, I had communicated those facts to the medical examiner's office. That way they would document it, but also be prepared to investigate the case with the most up-to-date information available.
Now, at that time that you made that statement to the representative from the chief medical examiner's office, had you been to Good Samaritan Hospital and seen Mr. O'Keefe at that point?
I have not.
And had you obviously seen any of the injuries that Mr. O'Keefe had sustained prior to making that statement to the medical examiner?
I had not.
Now, as far as the information that you received, you mentioned first responders indicating that the defendant had stated, "I hit him." Who was the first responder that provided that information?
The Canton Police Sergeant Good.
In addition to that, did you or Trooper Proctor speak with any of the Canton fire personnel?
Yes, we did.
And who did he speak with?
I believe it was firefighter Fleming.
So firefighter Flamani, is that correct?
That's correct.
Now, after going to Good Samaritan Hospital and viewing Mr. O'Keefe's injuries, as far as what you had earlier reported to the medical examiner, what, if anything, changed based on those observations as far as your opinion as to what had transpired?
Based on what I learned from observing the injuries, I could tell that the glass.
Objection.
No, I'm going to allow it. You can move to strike it, but I'm going to allow it.
Objection. I'm going to allow it, but you can move to strike it. So if I end up being wrong, just go ahead and move to strike, and then I'll strike it. Now, what's interesting is they don't end up moving to strike it. It ends up being fine. It's kind of a nothing burger, not a big deal what he testifies to. But for that ruling, for her to rule like that, tells me, like, in her mind, she is going to shoot first and ask questions later. She is going to apologize, ask for forgiveness and not for permission. She is going to try to backtrack things that come out, which we all know you can't do. You can't put the toothpaste back in the tube. You can't unring the bell. Once the jury hears it, moving to strike it, like, just so you know, all of you guys that are not lawyers, and I know there are some lawyers in here, but all of you guys that are not lawyers that think, well, once we hear it, what does moving to strike even do? A lot of people have asked me in these videos, like, what's the point of striking something? Once the jury hears it, they hear it. Guess what? Lawyers agree with you. Judges agree with you. That's no secret. We all agree. The damage is done. Now, it affects certain arguments and affects the record. It affects the record for appeal and things like that. So that's why, technically speaking, you should move to strike as a lawyer. But the jury hears it. So to say something like that is absurd to me for a judge to say that. Crypto tax lawyer, this does surprise me as well. But there are quite a few judges that are PDs. But that is surprising. And I think it's interesting for the chat to hear. All right. I'm going to jump ahead a little bit to recross. Jackson wants to talk more about the statements from Karen Reed.
Yeah.
Yes.
I'm sorry. Does that refresh your recollection?
Yes, it does.
What did you say to the, or what did you report to the OCME?
That there was a possibility that the decedent was struck to the face with a glass.
You also, with regard to the phrase, I hit him, or the Sergeant Good and or Flamati telling you that she said, Ms. Reed said she hit him. When did Sergeant Good tell you that?
It would have been during our conversations at the police department.
And when did EMT Flamati tell you that?
He never told me that.
So the only thing you were going on with regard to the phrase or the statement that you claim my client indicated, where my client indicated she hit him, is coming from Sergeant Good.
That information at that time was provided by the first responders from the scene.
And Sergeant Good then relayed that to you, correct?
At some point, yes.
Is there a single report memorializing that Sergeant Good reported to you that morning before 10:41 a.m., before 10:41 a.m., that my client made the statement that she hit him?
I don't believe so.
I want to shift gears real quick to the video. A couple of quick questions about that.
Pretty interesting timing of how and when this stuff happened. So he didn't receive the video. Now he didn't secure it. He didn't get it. He didn't take it. But he didn't get it till after the trial started. And when asked where he got this video from, it is the Canton Police Department. Isn't that interesting? Yes, thank you, Bex. Everybody hit that like button. If you guys have not hit the like button, please hit it. It really helps for anybody else interested in this trial and this content to come hang out with us, ask their questions, and dig into this with us. Noel, after all that's gone on in court, especially the last few days, I feel sorry for John O'Keefe's family. They have to know that they're not going to get justice unless the FBI finds something major. So this was one of my overarching feelings when Proctor was on the stand, was like, this is disgusting. This sucks. This casts a shadow over this whole case. And who really is the one left with the worst feeling at the end? And it's John O'Keefe's family. The lack of just cleanliness and straightforwardness in this investigation. I don't know how they don't leave with some kind of questions. I hope they don't. I hope there's some kind of closure, but even the Proctor stuff, it doesn't prove that the Alberts beat up John O'Keefe, right? As bad as today was for the Commonwealth, and we're going to get there, it doesn't prove what actually happened to John O'Keefe. And we're gonna get to that. Let's see if there's anything else with this witness. Nothing else with this witness, but then we get to Nick Barros, and I'm going to give Lally some props. I haven't given him very many props on this channel. Kevin Costello said, "You there yet, Peter?" I actually think today didn't have a ton to do with the Alberts or what happened in 34 Fairview, but it did have a little bit to do with maybe a cover-up or the police confirmation bias. So we'll talk about that, Kevin, when we get there. What Kevin's asking is, do I think there was a cover-up yet? And the answer is no, but I think we are an insurmountable ways away from proving this case beyond a reasonable doubt. And that's basically just as bad as if there really was a cover-up. But, you know, we'll get to that. Ashley and a bunch of people have questions about Barros. So I'm going to give Lally props real quick. This might have been the first witness I felt like he actually got to the point relatively quickly without a million backup questions about where he drove, how long it took him, what he put on in the morning before he went to work, what his normal schedule is, all that stuff. And we kind of get to the meat and potatoes of his testimony. It was pretty short and sweet, but this was very interesting to me.
And if you recall, from where you're standing at the point of the garage, was what part of the vehicle was facing you? Was it the front of the vehicle, the back of the vehicle, the side of the vehicle?
I was looking at the left side of the vehicle.
And at some point, did you make any observations of the right rear part of that Lexus SUV?
I did.
And what, if anything, did you observe about that area of the vehicle?
I saw that there was some damage to the right rear taillight. To my best ability and recollection, that tail.
There was some damage to that right rear taillight, okay? And to his best recollection,
Light was damaged to the right rear taillight. To my best ability and recollection, that taillight was not completely damaged. It was cracked and a piece was missing, but not completely.
I mean, why call this guy? Unless you knew the defense is going to call him, you already have people testifying like Yuri, it was smashed, there's all these pieces, blah, blah, blah. You have other people saying that. But Ashley points out, cracked with a piece missing. I actually thought, now, like relevancy wise and proving this case, I thought this witness might have been more important for the defense than Proctor. Cracked with a piece missing, which is like exactly what the defense's theory of the case is. And this guy wanted to make sure, everybody knew it wasn't smashed like it had been hit with a hammer and 50 pieces were going to be found. Let's listen to it one more time.
I saw that there was some damage to the right rear taillight. To my best ability and recollection, that taillight was not completely damaged. It was cracked and a piece was missing, but not completely damaged.
And then beyond the taillight area of that vehicle, what, if anything else, did you observe as far as damage to the rear passenger side area?
Like a dent on the rear quarter.
And as far as the dent on the rear quarter of the panel that you saw, was that above the taillight, below the taillight, or something?
It's probably right in conjunction with the taillight in that same area.
And from the time that you made these observations of the vehicle, at any point did you go sort of physically up to the vehicle?
I walked up to the vehicle, correct.
And about how far away from the vehicle did you get?
5 to 10 feet away.
And as far as the sort of outside or exterior of the vehicle, we mentioned obviously there's about 4 snow on the ground. What, if anything, precipitation-wise or weather-wise, was around or on the outside of the vehicle?
Just snow.
And in particular, in this area of the right rear passenger side of that taillight, was there any snow or ice or anything around that area that you observed?
On the vehicle itself?
Yes.
Yes, on the vehicle there was snow on the vehicle.
So they even confirmed he walked up to it. Maybe they want to get out the dent part, that it was dented, and that somehow proves it. But I think this was a good witness for the defense. And I think the defense thought it was a good witness for the defense because there was no cross. No reason to cross this witness. All they would have asked him is, was it cracked or did it look like it had been smashed? And they didn't need to. Was there a piece missing or 40 pieces missing? I thought this was a big witness for the defense. And then we get to Michael Proctor. Michael Proctor, the witness we've all kind of been waiting for. Let me hit some questions before we get there. Mildred said, Sergeant Barros from the Dighton PD told the jury the truth. Taillight was not shattered and missing 45 pieces, 15 plus hours after the Commonwealth alleges it was. How does that not make a directed verdict in favor of Karen Reed? Not a no-brainer. So if you just want to talk legally speaking, in cases like this, they can go to the judge and say, one piece, we put all the pieces together to make one piece. He said one piece. He didn't actually mean it couldn't have been shattered into a bunch of pieces. He agreed that it was busted, not completely busted. We showed the taillight. It wasn't completely busted. A lot of it was still intact. So our evidence matches up right in with what he said. In a light most favorable to the Commonwealth, him saying the broken taillight with a piece missing lines up with the rest of our facts good enough. It's not going to be enough for a directed verdict. There's just, it wouldn't be in any case what he said. Now, very good evidence for the defense, for reasonable doubt, for them to make their argument and line up their theory of the case, but not enough for a directed verdict. Christy, I don't understand the Commonwealth strategy. Every witness feels like a witness for the defense's case. Is it just me? I wouldn't say every witness. Like Yuri didn't feel like a witness for the defense, even though there were some credibility issues and the defense got some points. But I think this is what a bad case looks like to prosecute. This is a tough case to prosecute. Nicole, so sorry, off topic, but can you break down Young Thug's attorney being held in contempt at some point? Yes, I will. I think I'm going to do it tomorrow with my dad if I can have time to take a look at it. Brian, Peter, man, we get a rapid fire reaction to the debacle with Young Thug's case. Defense attorney locked up, contempt for calling out judges ex parte with the state and witness. I will tell you, and this isn't going to surprise you, the defense attorney was absolutely right in the way he handled it. I am pretty appalled at that judge. And that frustrates the crap out of me and my dad even more so. And that's why I want to bring him on tomorrow to talk more about it. Benny, if rumors are true that Judge Cannoni's brother represented Chris Albert on a prior case, should she ever recused herself? I would say yes, but I don't think it's an automatic recusal. So it's probably some kind of judicial discretion. KPAC, this made me laugh when I read it real time. Keep your voice up or I'll turn the AC on. The AC ain't going off here. It's about 100 degrees outside. Peter, are they ever going to mention the snow that's already in Sallyport? Yeah, I don't know the answer to that. Like, are people saying that the car was in there and then they took it back out and brought it back in and all that snow was from falling off of her car? I don't know the answer to what the importance of that is, honestly. If the Sallyport is motion censored, where's Higgins? Good question. My favorite line was when Alan said, were you being objective or were you objectifying? Betty's been waiting weeks to say that. Yeah, so we're going to get into Proctor now. So Michael Proctor, one of the really interesting things I felt was when he said that it was reported to him that John O'Keefe still had a 10% chance to live, which just like broke me inside to think about whether it was Karen Reed, whether it was the Alberts, whether it was a snowplow driver, whatever, whoever it was, whoever put John O'Keefe in that position, maybe if he tripped and fell and landed on the back of his head in the front yard. It is so sad to think all those people walking by right outside a window that they could clearly look out and see out. They all said, yeah, I saw the black SUV. I saw this car. I saw this Jeep. And nobody could see him laying in the yard. Anybody seeing him laying in the yard could have saved his life. That hit me like right off the bat when they were talking to Proctor. I was like, that is mortifying to think about. Oh, brutal to think about. Went through the background, talked about how he had never met Karen Reed, Roberts, McCabe, a lot of people. He went around that day with Yuri, interviewed the McCabes and Brian Albert individually. Never met Brian Albert before. His observations to John O'Keefe's injuries at the hospital were very similar to other people's. He has motor vehicle accident experience investigation. Sometimes shoes fly off. That's an indication of a motor vehicle accident. Fine. But then I thought this was really interesting as well. So in our real time, but the very next witness from Barros, this is how Proctor describes the taillight damage.
Defendant's vehicle. You mentioned some damage that you observed to the right rear passenger side area. Is that correct?
Yes.
Can you describe to the jury what it was specifically that you observed as far as damage to that area of the vehicle?
Yeah, the right
rear taillight had such large pieces missing from it.
So, I mean, that right there is inconsistent. And I get the prior comment about the directed verdict. I get it. I get your frustration. I get your frustration. Very few cases are JOA, judgment of acquittal, where they acquit the defendant after the Commonwealth's case in chief. If there was going to be one, I would say this would be on the list. But it's I wouldn't expect it, if I'm being honest with you, of how I think this is going to go. But that is completely inconsistent with how Barros, how he described it, right? Cracked with a piece missing versus a bunch of large pieces missing.
Rear taillight had such large pieces missing from it.
So you proceed inside the home, and where is it that you're directed, and where is it?
We're invited into
So they go into Karen Reed's parents' house. They have a 30 to 45-minute conversation. They take her phone in her car. They didn't get into what was said in the conversation. They took it to the Sally Port because it was heated. And then he starts discussing Canton PD's recusal or conflict of interest. And I thought his explanation was a little interesting.
There's other troopers conducting interviews. So at the end of the night, members of my office met in a conference room at the Canton Police Department to exchange information as far as what everyone had learned throughout the day.
And as far as that meeting is concerned, that's just troopers from your unit, from your office, is that correct?
That's correct.
And so there were no members of the Canton Police Department that were present for that, is that correct?
No, correct.
And do you know why that was?
They had taken a step back from the investigation. They weren't going to participate in any interviews or anything of that nature.
And how was that communicated to you and Sergeant McCann?
The best of my recollection was that debrief.
So he first says they're going to take a step back from the investigation and not do any interviews or anything of that nature. Interesting.
Meeting that we were informed that essentially Canton PD would be taking a step back from the investigation, and that now this is just solely a Norfolk State Police investigation.
Then he says they're going to take a step back from the investigation again as a whole. And Norfolk and other people were going to handle it, but not Canton PD, the investigation, not just interviews. As he answered that question almost 3 times in this little exchange, definitely seems wider spread than some of the other witnesses testified to, which I found to be very interesting. We have 18,000 people in the chat. That's wild. Tons of questions. I'm going to get to as many as I can. Make sure you guys hit the like button. We haven't ever had 15,000 likes on a video, so let's go ahead and get there. If everybody hits the like button, we blow past that.
So before we get to sort of the debriefing and all that's covered in that, as far as when you're on call, you get a call for any kind of sort of homicide or unattended death or anything like that. You then become what's called a case officer for that investigation. Is that correct?
Correct.
And can you describe for the jury sort of what the duty or the role is of the case officer vis-a-vis the rest of the members of the unit?
So essentially, a case officer is more of a facilitator. You kind of delegate out tasks, coordinate interviews. The case officer isn't the sole decision maker. I have supervisors. I have that we bounce ideas off of. I get feedback from. I also keep them updated. It's a collaborative effort in each investigation. We're a small office, so when a homicide comes in, everyone essentially drops what they're doing, and we all work on it together. So it's a collective effort to work on these cases. And essentially, the case officer is just kind of the record keeper of all the reports that come in and video that comes in. But when it comes down to decision-making time, it's a group effort.
Now, with reference to that collaborative effort that you were just discussing and this sort of debriefing meeting, so there were other troopers doing other things or other tasks throughout the course of the day of the 29th, correct?
Yes.
And so what was sort of the purpose of or not specifically what was discussed, but in general terms, what was discussed during the course of this debriefing?
The taillight piece is found at 34 Fairview Road by CERT. The one sneaker found at 34 Fairview Road. Interviews conducted, and then Sergeant Mechanic and I have shared everything we had kind of learned throughout the day as well.
And that debriefing meeting, if you know about how long.
All right. So then he confirms basically that he didn't go in, he didn't mess with the tail light. It was broken. It looked like that the whole time. He did, Lally got him to testify kind of to the motion sensor stuff. They struggled to kind of get through that over some objections and leading questions. The judge gave him a hint and was like, the reason I'm sustaining these is because of lack of foundation. Ask him how he would know that, Mr. Lally, after he lost like 5 objections. But again, one of the most interesting things and one of the biggest questions I've had the whole time is, why are you going back to Fairview over and over again? And this was his explanation of all the times he went back to Fairview and why he did that.
Pursuit for more evidence.
Now, as far as you mentioned, as far as dig out the snow in pursuit of other evidence, what, if any, tools or implements did you and the other troopers bring with you in order to effectuate that on February 5th?
We just had kind of standard snow shovels.
And with respect to that, as far as going back to 34 Fairview Road, and let me clarify as far as that's concerned. Prior to that date of February 3rd, 2022, had you been to 34 Fairview Road at any point in time in the course of your investigation?
No.
So that morning of February 3rd, that's the first time that you went.
Correct.
Now, with respect to, is that how many times did you go to the area of 34 Fairview Road over the course of the next sort of days and weeks in regard to potential recovery of items?
So February 3rd, I retrieved items on the 8th, the 11th, and 18th, and we was out there on the 10th with Sergeant Mechanic as well.
So to count that, it's the 3rd, the 8th, the 10th, the 11th, and the 18th. 5 times over 2 or 3 weeks to 34 Fairview. Nobody has given a normal explanation as to why.
Now, as far as any of those occasions that you just described, that you went to the area of 34 Fairview Road, on any of those occasions, were you by yourself?
No.
And with respect to those other occasions, what type of people, who was with you? I know you mentioned on the 3rd, but beyond the 3rd, those other occasions that you described, who was with you?
On the 18th, I believe it was Trooper Chico, based on the handwriting on the evidence bag, kind of recognized his handwriting. And the other 2 dates, I don't recall who was out there with me.
Now, with respect to items that were located, starting with the 3rd, do you recall specifically what, if any, items were located on the 3rd?
We've located a black drinking straw, consistent with the one seen in the waterfall video of Mr. O'Keefe walking out of the bar holding the glass.
Oh yeah, that grainy video with the black straw was definitely consistent with that. Like, these are the types of things where I'm like, okay, yeah, it was this straw is definitely the straw we see in that grainy video in his hand. That's like this big, that, you know, nobody could tell if it's the same black drinking straw. You can maybe see that it's a straw and that it's black. That's it. But like, to say these are 2 of the same straws, just, that's the type of stuff that's annoying with cops. And this guy is going to be beyond annoying as we continue. And he is like, all that's wrong with law enforcement. These cops are some of the reasons why defense attorneys get really frustrated and hammer cops and look bad, and people don't like them when they do it to certain cops, because they like to believe cops are all honest and good people, and there are really honest and good cops, but there are also some really dishonest and bad cops, and we just have to realize that. And we have to judge law enforcement officer credibility just like anybody else's. Just because they wear a badge and a uniform and they sign up to do something that's supposed to be protect and serve doesn't mean they're going to be credible, honest, good people. And I think this trial has highlighted that, and this guy is like the epitome of it. Literal epitome of it.
We located his hat that had the American flag that was deep underneath the snow. As we were digging, we discovered that. We further discovered other pieces of plastic as well.
Now, as far as these return trips on successive dates to 34 Fairview Road, what was the reasoning behind that, or what was sort of the plan in reference to why were there so many different dates that you returned to 34 Fairview Road with other troopers?
So after the 29th, there was close to 2 feet of snow that had fallen. And in the days and weeks that had followed, the temperatures ranged from 30 degrees up to 60 degrees. And there was about a half a dozen days mixed in of heavy rain. So as the snow started to melt, more evidence started to present itself.
They had to go back. So in one collision, according to the Commonwealth, Karen Reed's SUV hit John O'Keefe, smashed the taillight, pieces went everywhere, and they had to go back 3, 4, 5 times over 3 weeks in order to continue to gather evidence. Okay? In the snow, red piece of plastic and taillight and clear piece of plastic and taillight. Remember that. Just remember that sentiment and that statement and that logic.
So there were items that you recovered on the 3rd, and then items you recovered on successive dates that weren't visible or you didn't see on the 3rd, correct?
Correct.
Now, if I could, keeping you on February 3rd, you mentioned that there was a Trooper Evan Brent that was
Going to jump ahead now
Mr. O'Keefe's vehicle.
to when the defense says Karen Reed's car hit John O'Keefe's, and maybe that's when she cracked and lost the piece of her taillight. And here's how he explains how that's just an impossibility.
Concern. What, if anything, do you observe like on Mr. O'Keefe's vehicle at the time?
There's some snow. You can see on the back window here, the bumper and the windows here is starting to be covered in snow.
And as far as when that vehicle comes close to or makes contact with Mr. O'Keefe's vehicle, what, if anything, do you observe the snow come off the car at that point?
I do not know.
Now, with reference to the back area of Mr. O'Keefe's vehicle, specifically in the area of the ground, as far as that area on the ground, what, if anything, did you observe in reference to any red pieces or any pieces of taillight or plastic or glass or anything in that area that you observed on the space?
So this area here is, you can see the white snow. There's no red pieces of taillight, which would show up in the contrast of the white snow.
Well, that solves that, right? Because for sure, and again, an imperfect Ring doorbell camera with the snow literally falling on the ground, covering parts of the camera. Like there are literally parts of snow with like white lines coming down where you can't see underneath them onto the floor. But obviously, if we're looking for red pieces of taillight, you would obviously be able to see them in this ring camera. And as I'm looking in this ring camera, you can't see any. Therefore, it couldn't have happened there. And I'm like, really? 4 minutes ago, real time, 4 minutes ago, you just said we had to go back 3, 4, 5 times to find these little itty bitty pieces in the snow. So let's just assume for a second that the defense says the light shattered the same way, which they don't. But let's just assume it shattered the same way. There would definitely be pieces you couldn't see. And I had so many people on Twitter like, you're an idiot. You're such an idiot. Obviously, you don't know what you're talking about because this happened in real time. And if she would have hit it, we would have seen the glass fly and we would see it sitting on top of the snow. The snow is actively falling. The pieces that were measured by the Commonwealth and law enforcement, some of them were very small. Pieces could have very easily gone underneath the car or could still be on the bumper, like there's glass still on the bumper and a hair still on the bumper of Karen Reed's car where you wouldn't be able to see it right here. The glass could be on John O'Keefe's bumper where you couldn't see it right here. There is tons of explanation where there could be pieces of the taillight that you couldn't see. I think you should be able to see him red in the snow. I think you should have been able to see him at 34 Fairview. The first time you searched, if not the first, definitely when they brought the experts out shoulder to shoulder with the tools. So that's the type of logic that when witnesses say this stuff to jurors, I hope in my trials that jurors are like, do you think we're stupid, sir? You just said it took you days, weeks to find the pieces at 34 Fairview, but then you won't even give the credence to the defense's argument. Now, if you want to say, and I thought it was good evidence, I see people saying there was damage on John O'Keefe's car. It didn't look like it to me. I get that, some people are saying it looked like there was damage. It looked like there wasn't. It didn't look like there was damage to me. That I think is better evidence to say it obviously wasn't that hard of a hit. No damage to John O'Keefe's car. Fine. Make a good point, and that's fine. And I'll take it and I'll move forward with it. Okay. They made a good point to me, and I get it if people want to disagree with me on that. But this type of logic, flipping it to work for your argument, is how you lose a jury, in my opinion. There are also, as we saw, clear pieces of the taillight which wouldn't be readily apparent in the snow. And I don't know if the defense is going to talk about that when they cross him, as they've just kind of begun their cross. There's a little bit more here, I think. Is there a little bit more? Yeah, a little bit more.
Is going to be running from that for a moment. Now, as far as the damage area that you were discussing previous that you observed in the January 29th in the Sally Port, February 1st in the Sally Port, and then the item that was just marked as evidence. What, if anything, do you observe in the right rear passenger side taillight area of the defense vehicle from this video?
You can see the inconsistent lighting. If you compare it to the left versus the right, there's a gap right there.
If what you observed from that video, does that appear to be consistent with what you observed on January 29th at the Kent Police Department, February 1st, and in the item of evidence that was just marked?
Yes.
Okay. Ms. Cumming, you can take that down. Mr. Officer, we can have the lights back on. Thank you.
All right. So the next part we get to is, they show the car, John O'Keefe say no damage. He shows the piece of the taillight to the jury, taking them out of the bags and boxes. It took forever. How many of these people were you friends with? How would you describe your relationship with, I think, the Alberts? And it's like they were acquaintances. Julie, Chris, and Colin were friends with his sister, but he wasn't really friends with them. They'd been at some of the same places, but his sister's his best friend. He talks to her all the time. Then they get to the chats. And I'm like, this is the part where we're going to answer some questions here first before we get to the group chats for Proctor. But this is the type of stuff that, unfortunately, movies are made of. But more unfortunately, that these are the guys, when you see this and you find this out about them, and you're some kind of supervisor or superior, you fire them. People joke about how it's hard to get fired from government jobs. Like, you fire them when you find these chats. They are despicable. They're deplorable. They're horrible. I can't warn about how disgusting these are that we're going to go through. We're going to listen to them because I think in order for us to try to determine what the jury's thinking and feeling, we got to kind of see and hear what the jury sees and hears as evidence. And I want you to keep this in your mind, okay? When I tell you how unusual or unprecedented it is to have the lead officer's private text messages produced and read to a jury between he and his buddies that have nothing to do with this case. He and his wife. Think about that. The law wants to protect people and protect privacy. They don't want to just have you producing your text message with your spouse. That's obviously private. Okay. That's how far this went. And of course, with the supervisors and other cops in the case. But keep that in mind, how unusual this is. We don't just get everybody involved. Like, I have witnesses all the time I think are lying, I think are hiding things, or I think are doing something. I can't just get all their personal text messages. That's not how it works. I have to have a good faith basis to show it. Or you request it from the federal government in their investigation. And that's how you get it. Jody, Peter, I don't know if you're covering the Long Island serial killer trial. I have an interesting story about him. Would you like me to email it to you? Involve me? Sure. LawyerYouKnow@gmail.com. Lindsay, why would the DA go to trial on this? It makes the Commonwealth look so bad. Why did the Commonwealth bring up Proctor's text? Fully expected that to come from defense. So in some cases, you get to the point where it's like you can't dismiss charges because the defense is accusing you of all this wrongdoing. And if you dismiss charges, are you kind of agreeing with them? John, there's no way I can cut that out. I don't know where they come. Pesky Pirouette. All of us with family members or friends who have disabilities or chronic illnesses are horrified after today. How would we should protect them from these cops? Honestly, your elected officials should protect you from this. As bad as that sounds, but legislators, state attorneys, the leaders of whatever the police department is in your jurisdiction, judges, the judge should hammer this guy. And if she hammers him enough, they know that this guy can never testify again. And if he can't testify again, how's he going to work? There's ways the system can get rid of people like this, and they should. Becca T, is it possible for the feds ask the DA to take this to trial to gather more evidence for their investigation and agree to exonerate Karen Reed or dismiss shortly before trial ends? I would be surprised. Pillar, do we think Lally is going to wake up tomorrow and say to himself, gee, I'm really crushing it? There's no way after having Proctor read these text messages out loud that he could be thinking that. Just no way. No way. Pity. If defense successfully proves a cover-up and or conspiracy, who brings charges against the Alberts? Can police and or MSP? I mean, I guess the Attorney General's office, potentially, the federal government, but I don't know. Be tough to prove that they committed the crime against John O'Keefe. Now, other crimes, maybe. Sierra, why don't they show Barros a photo of the missing taillight and ask him to verify that's what it looked like? Maybe both sides would be afraid of that. Maybe both sides just want to get enough to be able to make an argument based off what he says. That's happened sometimes in trial. I don't know the answer. Because, I feel like we could have a lot more pictures of the taillight right away, right? Chance, Commonwealth thinks they're going to lose. Commonwealth has inside info of the Fed case and trying to distance themselves from corrupt law enforcement investigation. I have no idea. They're putting these witnesses on and letting them testify in front of the jury. If they knew they were lies or felt they were lies, they couldn't do that. They literally couldn't do that. What if the feds reveal their investigation results while the trial is happening? That would be crazy. We know the U.S. Attorney and DA don't get along. That would be highly unusual, highly unusual. Evil Queen, shouldn't Karen just have refused without warrants? Yeah, she could have, but eventually they would have gotten it. Jonathan, missing large pieces, should not he be saying big part missing or most of it's missing, not large pieces, plural? That's clearly a coached testimony. Yeah, it does feel like it fits right in there with what they're trying to say. Ken H., did you catch where Proctor stated something about multiple ME reports and the defense objected? Is it possible the defense messed up there? I don't know, but I do know he talks about the ME reports, and we're going to get to it in the text. Let's get to the text now for Proctor. And John asked me to skip ones that use certain words. I'll try to do that, but I don't know exactly where they were. So let's jump to
From the start of the first text, so the owner of the house?
Yes.
So the owner of the house was a woman cop that beat him? That's what I initially thought after talking to Can paramedic. Then I saw.
So after initially talking to the paramedic, he thought a woman cop inside the house beat him. So just at some point they thought that, okay? Yet they didn't try to go into the house. They didn't try to search the house. They didn't interrogate anybody in the house like they were criminals or even potential suspects. None of that. None of that. Found that very interesting.
Other guy.
And those last two are your responses, is that correct?
Yes.
Now, the following text messages are from your friends, is that correct?
Yes.
What do they say?
Here, let's focus. What does she waffle to mean? What's the story? I responded, she hit him with her car.
And the she that you're referring to there, who is that?
Miss Reed.
Now turning your attention to the next
She's
page.
telling people she hit him with her car. Not unusual for cops to kind of jump to conclusions.
2535. Again, if you could start at the top of the page and read through that page and just indicate to the jury who is talking and what is being said.
Okay. My friend in Tennessee states, okay, that's fucked up. I respond, intentional or not. Then another response, gotcha. He was
So intentional or not, meaning they obviously believe maybe this wasn't intentional. It's interesting to hear a cop's initial reaction, like early on, how they look at the case, right? Very interesting to read these text messages. And I'm interested to see how the jury will respond to them eventually.
frozen in the driveway and she didn't see him, question mark. That's another animal we won't be able to prove. And he was frozen in the driveway and she didn't see him, question mark. That's another animal we won't be able to prove.
So he's admitting that there are elements to this that they won't be able to prove. Like, was he frozen in the driveway and she didn't see him? The Commonwealth has the burden of proof, the highest burden in the land.
And then I respond, they arrived at the house together, gone to an argument.
I didn't speak out loud or out of turn.
If the objection's overruled.
Your Honor,
But
if I can say this, there needs to be an identifier of who's speaking.
I understand what you think the mix-up is. So, Mr. Lally, go back.
Thank you.
Sir, if you could please, again, start at the top of the page and just indicate.
No, just after the gotcha, he was frozen in the driveway, correct, Mr. Jackson?
That's correct, Your Honor. Thank you.
I respond, that's another animal we won't be able to prove. I follow that up. They arrived at the house together, got into an argument. She was driving and left. 71 number responds with, what's the name of the can cop living can? The other one involved.
And how do you respond to that, sir?
There's several other messages before I issue a response.
Objection again. Bottom of the page.
So it's not an objection, but Mr. Lally, why don't you point to him?
So, sir, at the bottom of page 2535, you have a response. Is that correct?
Correct.
And what is that response?
They arrived at the house together, got into an argument. She was driving and left.
Objection.
So it's going.
Not reading it right. I don't know that it's intentional. The defense thinks it's intentional and they're annoyed. They want to know the response to who is the other Canton cop involved.
Going to be a matter you can address on cross.
There has to be some accuracy. with the reading.
So I understand. So, Mr. Lally,
Yeah,
why don't you go point for your
Let him read it incorrectly. I think there's a sidebar here. If there is, I'm going to skip through it.
witness?
May I approach, Your Honor?
Yes.
So you point out.
Can I see what you have for a second, Mr. Lally?
2535,
Vehicle.
correct?
Correct.
What, 2535, you indicated Biff him, correct?
Correct.
What did you mean by that?
That Miss Rita struck Mr. O'Keefe with her vehicle.
Now, sir, if I could direct your attention to page 2537. Now, do you see a response toward the bottom of the page from yourself, January 29, 2022 at 11:04 p.m.?
Yes.
And can you read that response to the jury?
Yeah, but there'll be some serious charges brought on the girl.
And what did you mean by that, sir?
That throughout the course of the day, we had compelling evidence that Miss Reed struck Mr. O'Keefe with her vehicle.
And you have two responses from friends, same friends, at the bottom of that page, 2537, is that correct?
That's correct.
And what are those responses?
Keep your voice up loud, please. Trooper Proctor, jurors can't hear you.
Yes, Your Honor. Number ending 5051. Got to be. I can only imagine what internal affairs of the BPD are trying to get out there. The second response, same number. She hot at least.
Is she hot at least? So now we start getting into some stuff that's less relevant. All that was kind of relevant to the case. Like, what does he think about the case with everything that he knows?
And turning your attention to the next page,
I
25.
mean, relevant to proving the actual facts of the case. His bias and how he treats Miss Reed and what he says about her is absolutely relevant to this trial. It's not necessarily relevant to, you know, was she driving? Where did she hit him on the lawn? Things like that. What can they prove? What can they not prove?
38 at the top, if you could just read a number series of responses from yourself, correct?
Yes, sir.
Read from those, sir.
Yep. So these came from me. From all accounts, he didn't do anything wrong. She's a whack job. CUNT.
All right. So this is what John wants me to skip. So there was an objection, and the defense basically wants him to say it. The judge makes him say it. And I saw some people earlier in the chat saying, do you feel like the judge's demeanor started to change in this case? I don't know if I'll say it started to change, but she, in my opinion, does not like Trooper Proctor. Can't blame her. I don't think anybody else in the courtroom does. And now Lally is going to go through some of the most despicable and damning texts to try to pull the M&M, right? To say everything you have against me before you get to say it. And there are two sides to this coin. Number one, you can do it this way, where you say it, you try to pacify it, you try to take away some of the sting, you try to let him explain it so it doesn't sound as bad, and the first time they hear it is on direct. And that's what he did. The second side, and I think what I would have done, I get what he was trying to do. It didn't work, in my opinion. What I would have done is say, now that we're done with the parts of the text that have to do with this case, did you have any personal conversations about Ms. Reed? How would you describe them? They were derogatory, they were unprofessional, they were horrible. What are some of the things you said? And then list off some of the things you said. How do you feel about that, knowing and reading back that you said that about Ms. Reed? I feel horrible. I shouldn't have done it. It was bad. I said stuff about Mr. Yannetti. I wish I didn't. Why did you say that stuff? I was so mad that, she killed a cop, and, I hate people that are cop killers and whatever. Go that route. Let him explain his anger, about it being a brother cop, and we all stand together and whatever. Now, of course, defense could use that against you, but do it that way in kind of a group explanation so that it takes away the sting, in that the defense is going to have him read them. It's going to be bad. We know it's going to be bad. But now I think they've heard him once on direct. I think they're going to hear him all again, just as bad as they ever were on cross. So now they're going to hear him twice, two different ways. The defense is still going to have their haymakers with these texts. There's no perfect way to deal with horrible evidence like this, okay? So it's all, kind of strategy and what you want to try to do, and you do the best you can as a lawyer. That's how I would have handled it, but I understand why people may disagree.
So, no ass.
So he says she has no ass. Okay, there's so many comments here. We're going to get to some of them. We're going to just kind of explain overarching how we think this is going to affect the case, because I do think it's going to affect the case.
Sir, what is it that you were referring to there? Why would you text that?
These were, from all accounts, he didn't do anything wrong. Is talking about the homeowner, Mr. Albert. I had mentioned the compelling evidence against Ms. Reed at this point indicated that Mr. Albert had nothing to do with Mr. O'Keefe's death. The rest of the unprofessional and regrettable comments are something I'm not proud of, and I shouldn't have wrote in a private or any type of setting.
And we're about to hear more of those.
Sir, at some point, if I could turn your attention to page 2540. And there's a photograph that's shared within this text communication. Is that correct?
Yes, sir.
And does it indicate who shared that photograph? On the prior page, possible.
The number ending in 5051.
And who is depicted in that photograph that was shared within the group text?
It's Ms. Reed being escorted out of the State Police Milton Barracks.
And these are all from February 1st of 2022, around that time frame. Is that correct?
Yes.
Now, sir, if I could direct you to page 2543. And sir, if I could direct you to the top of the page and ask you to read through that page, indicating who's speaking and what the content of those communications are.
Again, 4146 question mark. I respond EH. I respond again, nutbag, as chief would say. Okay. Number ending in 4146. Question is that chick of smoke? Again,
that chick of smoke, again, him and his buddies talking about her, somebody who's a criminal defendant who he's investigating. Nancy Cook said, Peter, of course it's terrible, but how can you not show just as much compassion for Karen Reed, who is to be presumed innocent? I hate, if she's being framed, obviously that's horrible. And I do, feel for her. And I think that, I hope this goes the right way if she's being framed. It's not the same thing as your son being left to die in the front lawn. I don't think it's the same thing. I'm not saying I don't have compassion for her. I do. This case isn't over. Yes, she's absolutely presumed innocent. Absolutely not guilty right now. You have to vote for that. and this is horrible. Nobody should have this stuff said about them. Absolutely. Absolutely. But there is a victim in this case, regardless of who the defendant is and who did it. And I don't think that's being overstated. I hope. I don't know how I would be able to overstate that.
4146 question mark. I respond EH. I respond again, nutbag, as Chief would say. I also respond with, she's got a leaky balloon knot, leaks poo.
She's got a leaky poo knot, leaks poo, something like that, which these get into the most despicable parts, in my opinion. So we know that she has medical issues. We know that she potentially has had procedures or things that would create bowel issues. And that's what he's doing, making fun of her. Like put yourself in the shoes of a juror. This is supposed to be a professional guy, lead case agent, has his fingerprints all over everything in this case. And this is how he's talking about the defendant. This is what he thinks about the defendant. He's making fun of her medical issues. He's judging her hotness, telling it to a friend. He's objectifying her. He's demeaning her. And we're supposed to believe that he just like took this case like any other case, handled it professionally, did the interviews, just kind of did his job. Mary Claire asked, Peter, is the jury allowed to consider witness integrity when considering the facts? Absolutely. Witness credibility is one of the most important things in most trials. And I will tell you, I think one of the defense's strategies in this case is going to be a vote for guilty is a vote for Michael Proctor. Is that the guy whose side you want to be on? And whether you agree with it or not, right? And whether or not it's the actual facts of the case, and whether or not it's the whodunit, and whether or not it's beyond reasonable doubt or any legal standard. If they can get this jury to believe that you go with this guy, you ratify his police work, his investigation, you also ratify his text messages and his despicable talk and the way he treats other human beings. This isn't the only case he does this in. This is this guy's character. And he'll sit up there in trial and say, oh, these were unfortunate and I shouldn't have said them. We got him in black and white. Do you really think he would have admitted this if we didn't have the text messages? You want to vote with this guy? And there's even more coming about making sure you get certain things in this investigation. And people may be giving you things for certain things you did in this investigation. After Proctor's cross, I expect it to be so far away from proving this case beyond a reasonable doubt that I don't know if the Commonwealth can recover in 3 months, let alone 3 weeks. They don't even have 3 weeks because the last week is going to be the defense's case. So what do they have? 2+ weeks left? I don't know how you recover from this unless they have the greatest accident reconstructionist in the world that's going to prove exactly how the broken taillight pieces match up with the scratches on John O'Keefe's arms. I'm not seeing it. And I think you're right, Mary Claire, and I think this is an insurmountable witness for them. I don't think they had a chance. I'm sorry. I don't think they had a choice. I think they had to call him because the defense was going to call him. And I actually think it was the right move to call him and do your best and get some testimony out and not have the defense be able to say, we once again had to bring you the truth. Just like we had to flip the video, we had to call Proctor. So don't give them that opportunity. At least you took one argument away from them because they're going to have all the other Proctor arguments still.
And what, if anything, is that in reference to?
Again, to Ms. Reed's some medical conditions there. Again, unprofessional comments I should not have made that I'm not proud of.
Well, good. I'm glad.
As far as attitudes expressed within these text messages and other text messages, what, if any, impact did that have as far as your investigation was concerned regarding these?
Yeah. Yeah. How did your disgusting and demeaning comments, how did they affect your investigation? What do we expect him to say here? Like if you're sitting on the jury, what could he possibly say? What could he possibly say?
What, if any, impact did that have as far as your investigation was concerned regarding these?
These juvenile, unprofessional comments have zero impact on the facts and the evidence and the integrity of this investigation. They said these are unprofessional comments, but they absolutely do not detract from the integrity of the investigation or the facts and evidence of it.
May I approach this retreat?
Yes.
Now, Trooper Proctor, contained within, you've seen text messages amongst yourself and a variety of different people from that same sort of iCloud area of your personal phone.
All right. They just do some more background here. He also talks about how he texted his sister after he interviewed Jen McCabe. And he's like, oh, she said she knows you. It's like, yeah, she's friends with this person and that person and whatever. Like immediately in real time, he's connecting these dots, which the defense also connected throughout the case.
Again, if you could read through as far as who's speaking and what the contents of those messages are.
I texted my sister, what's up? She responded, nothing. I just saw Julie, and she said, when this is all over, she wants to get you a thank you gift. And I respond, get Elizabeth one. Elizabeth's my wife.
Julie Albert wants to get him a thank you gift when this is all over. And he says, just get it for my wife. Why would they want to get him a thank you gift? It's weird.
Okay, and my sister responds, because I guess her and Chris were friends with John, and she's so proud of you for leading this. And then she writes, Elizabeth, question mark? I respond with, she's been stuck with the kids for the last 10 nights. My sister responded with, yeah, but she knew what life is like married to a cop.
And sir, as far as the gift that's mentioned, as far as Julie Albert, is that anything that you have received at any point in time?
I never received a gift. I never asked for a gift. My wife never received a gift. She never asked for a gift.
How would you describe this context of this conversation or why that's being discussed at this time?
Again, I don't know the thought
What's
process.
really interesting about this, like we never asked for a gift, we never received a gift. It's like, would you have told us that these comments were made if we didn't have the text messages? Like the cross is going to be incredible. What we got today is like scratching the surface, is my guess.
Of my sister and Julie, as far as bringing that idea of a gift into play. Like I said, I didn't ask for one. I never received one. The same with my wife.
Sir, if I could direct your attention to page.
All right. Some more background. And then we get to more texts with his friends and Lally. And again, this I thought was good. You know, think whatever you want. Obviously, this guy's biased, but at least Lally gave him the opportunity to go ahead and list all of the compelling evidence that they have against Karen Reed through this, you know, exchange here. At least he gets that, if nothing else.
Reference to that particular time frame and the language that you used. What sort of information have you gathered to that point, and why would you say or use that particular language in your?
Why would you think she's guilty? Why would you be calling her these names? Why did you hate Karen Reed so much? This is a good question. You know, for this kind of witness, you can't be beggars can't be choosers. So it's like you get what you can get, and he gives them a chance to just rattle off everything they have on her. Now, the jury's listening to this. How much of this is really solid, trustworthy, credible evidence?
Particularly in your descriptions of the fact.
So this is, 16, 18 hours later, and I conducted multiple interviews.
Speak up.
Conducted multiple interviews. We knew Mr. O'Keefe never went into Fairview Road. We knew there was one shoe at the scene, one shoe at the hospital. Miss Reed's statements when Sergeant Buchanan and I interviewed her. Her broken taillight, the missing taillight, some taillight pieces found at the scene. The compelling evidence pointing directly at Miss Reed that she struck Mr. O'Keefe with her vehicle led me to make those comments. Whether, like I said,
So that's the state's case right there, right? That's what the investigation gave. One shoe at the scene, one shoe at the hospital. We know that he never went into the house, which obviously means we have to find the witnesses inside the house credible. The broken taillight pieces, okay? The way, like Mr. O'Keefe's injuries in comparison to a car accident, okay? So what else is there? Like, it feels like we've seen the whole Commonwealth case. The only thing that could save them is the best accident reconstructionist that shows tire tracks and using the car data, showing her backing up at a high rate of speed, slamming on her brakes, showing how it all lines up. Like, that's really the only thing I can think of right now that would save them. You guys let me know if I'm missing something. If there really are 10 females on the jury, I don't think Vegas has odds, but if they did. Again, we're going to jump ahead a little bit to him and Trooper DeChico's text exchange.
Text messages starting on April 28th, 2022 at 10:52 in the morning. Is that correct?
sorry, what was the time again, sir?
April 28th, 2022, 10:52 a.m.
Yes, correct.
And again, sir, with reference to this page, if you could read the content to the jury and please indicate who is speaking at each respective times.
Okay. I said out without a doubt, he's got diarrhea of the mouth too. Trooper DeChico, rookie move, not going into a meeting with the ME and getting that homicide determination. I respond, Yuri and I had two conference calls with her, sent her numerous photos, etc. We laid out the entire case for her. Trooper DeChico responds, not good enough. Should have had me or Jeff do it. I respond, if you two did it, she would have made it accidental or natural causes.
He looks up again after reading these texts as if they're innocuous and no big deal. But what that text exchange was one cop making fun of him for not getting this case signed, sealed, and delivered good enough for how he fed information to the medical examiner and laid out their entire case. And she still didn't come back with a good enough opinion for them. And he says, yeah, right, I did such a good job laying out this case. If it was you, she would have said it was an accident or natural causes. I mean, for somebody to say this was natural causes would really be something, right? So that's an admission that he was pushing this case on the medical examiner to make sure that they gave a good enough opinion, something they could use, more evidence. And to me, this isn't just Karen Reed's case. This shows what cops do in a lot of cases. They hone in on one target and they make sure they can prove it. It's just more obvious and blatant and despicable in this case because we've got a lot more evidence and digging into personal text messages and things like this that we almost never have in cases, and frankly are not usually entitled to like they are in this case.
And can you explain the context of those communications, or what exactly is it that you and Trooper DeChico are talking about in that communication?
Okay, so the ME is a medical examiner. They conducted the autopsy of Mr. O'Keefe. Our office is kind of a little bit of a locker room.
Hold on, wait for the ambulance and then speak up.
Autopsy of Mr. O'Keefe. So like I said, the ME stands for medical examiner. They conducted the autopsy of Mr. O'Keefe. Because I'll address the conference calls Sergeant Buchanan and I had with the medical examiner. The doctor had some questions as to the facts and evidence, kind of what had transpired, which is common. You know, even if it's a homicide, I've had many calls with the medical examiner's office. Even if it's a suicide or overdose, always with a homicide, the doctor wants to know what transpired. Trooper Chico and myself, we kind of like to bust each other's chops, go back and forth. So that's what he meant by saying rookie move.
Yeah, it definitely feels like busting each other's chops.
Not going into a meeting with the ME and getting that homicide determination. The original determination came back.
Sustained. Next question, Smelly.
So they didn't want to come. They didn't want. That's the objection. I think somebody else asked about. They didn't want him to read what the conclusion was or what the medical examiner's ultimate opinion was for some reason. I'm sure the defense has a reason.
Now, as far as attending the autopsy, is that something that typically someone within your office would do, within your unit would do with regard to any sort of death investigation?
Yes.
And do you know who attended the autopsy of Mr. O'Keefe in this specific case?
Trooper Connor Keefe.
And so as far as Trooper DeChico's reference to you not going in, or Sergeant Buchanan not going in, is that what you believe Trooper DeChico was referring to in that message?
Objection.
Sustained as to the form.
You indicated that you and Trooper DeChico busted each other's chops. Is that fair to say?
Yes.
And can you describe a little more, expound upon that as far as the nature of your relationship and sort of the text messages that you exchange in this and other communications that you have?
Basically just, kind of needling each other, and him doing that is by saying, texting me, rookie move, not going into meeting with the medical examiner. So that's a perfect example of him kind of just needling me, which we do on a daily basis.
And as far as your interpretation of that, did you interpret that as a serious comment or something said in jest?
I interpreted that as a typical joke from Trooper DeChico.
Now, may I approach the retreat?
Yes.
All right. At the end, he talks more with DeChico, calls her a whack job, says what the hell is inconclusive about what the ME is. Why did she come up with that opinion? Manner of death shouldn't have been undetermined, things like that. And then, all right, here's the last part, some more despicable texts. We're getting near the end of his direct. Going overtime tonight, people, so hang in. We're almost done. We're going to listen to some across too.
June 9th, 2022, around that time, sir.
If you like women who shit themselves.
Again, sir, what is it that you're referring to there?
Sorry.
Okay.
If you could read what you wrote on June 9th, 2022, around that time, sir.
If you like women who shit themselves.
Again, sir, what is it that you're referring to there?
Again, a regrettable comment I made about Miss Reed's medical condition.
Now, if I could.
So he says, if you like women who poop themselves, basically, again, making fun of her physical ailment. Your little offhand apologies, like, sorry, regrettable, I shouldn't have said it, like that does nothing for me. And I feel like, I'm not going to toot my own horn here, but I feel like I'm a pretty like forgiving person in these trials. And like, I try to be gracious and give people the benefit of the doubt in these situations and realize life's hard and things can be tough and you can have a bad day. Does nothing for me. Does absolutely nothing for me.
Good. Direct you to the following page, 2645. And again, if you could read from that page as far as who is, indicate to the jury who is speaking and what is being said on page 2645.
I'm speaking right now. The statement she made tonight at age 7 was mental. Thank Christ it was on BWC, which is body worn camera. Trooper Kukowski responds, that's her. Smoke. Trooper Kukowski again, what'd she say? I respond, said the Alberts beat the shit out of O'Keefe, left him for dead. And that's why her taillight was cracked. She's
I mean, confirming her story from the jump, right? I mean, that's basically what she said from the jump.
gross. Trooper DeChico, no, fuck her, bitch.
I mean, these are how all the cops are talking about her. Now, I will tell you, I can almost guarantee they talk about a lot of criminal defendants like this. This is not specific. Now, these comments are not specific to this case. When they think they got somebody, regardless of if they're right or not, and a lot of times they're right? Maybe I'd even hazard to say most of the time they're right. But it still is not appropriate to treat people like this and talk about people like this. And they start to just think of them as animals, basically. And it's really sad that these are supposed to be the people, protecting and serving the community and the citizens and paid by tax dollars. And this is shining a huge light on that. And there are a lot of amazing cops, and cops like this give them bad names and make you start to wonder about all cops, right? Just like lawyers, right? Same thing happens with lawyers. I get that all the time. People hate certain lawyers or hate a lawyer they know. And I get it. Because there are a lot of horrible ones out there.
Thanks, sir. Can I approach your retreat now?
Yes.
17/2022, 9:44 p.m.
Yes,
You see there's like sort of 3 responses from you.
I have you now.
If you could just read the 3 responses from yourself, sir.
Okay, so these came from me. Funny, I'm going through his retarded client's phone. No nude so far. I hate that man. I truly hate him.
Going through his derogatory term client's phone, no nudes so far. I hate that man. I hate him. And this was in response to a picture that was sent of David Yannetti. Ashley, I hope not, honestly. Nobody should see their dad like this, even if they are despicable like this guy.
Now, with reference to the investigation at this point, you're talking about his client's phone. Who are you referring to?
Miss Reed.
And with regards to the phone at that point, can you describe to the jury sort of what's going on during this time period of August 17, 2022 in regards to Ms. Reed's phone?
So after obtaining a search warrant for Miss Reed's phone, we weren't able to extract any data from it until August of 2023. Troopers in my office knew I was going through the phone that evening. I was most interested in location data, text messages, Google searches. That was the update I gave the troopers in the office.
Definitely wasn't actually looking for nudes, guys. I was just in there, doing other things, and I found some text messages with a lawyer, and I had to stop. At this point, like if you're Lally at this point, you might as well stop trying to get any legitimate evidence out of this guy because it's over. Saw some people on Twitter saying he's super credible and they really liked him at the beginning of Direct. Oof, that's a tweet that didn't age well. But if you're Lally, like, is the jury going to believe anything else this guy says? Like, you might as well just get through it, eat the bruises on your apple and move on. Toots. I mean, I'd need a new pair of shorts if this guy pulled me over. I'd be like, oh crap. Even if I did nothing, I know what this guy's capable of if I was a woman. Even as me, frankly. I don't think this guy has a line that he won't cross.
This was a distasteful joke. I should have gave a proper update instead of that. I wasn't able to go through the phone as thoroughly as possible because I came across some a text between an attorney and Ms. Reed, so I had to stop going through her phone, and I made my supervisor aware of those communications.
Now, just in reference to what you had just said, this is in August of 2022, is that correct?
Correct.
So after a search warrant is obtained for the defendant's phone, where did it go? You indicated you gave it to Trooper Garino, and where did it go?
Trooper Garino essentially hooks it up to a device called Grey Key, where he tries every possible combination passcodes in order to access the data contained in the phone.
And at that time, when you retrieved it pursuant to the search warrant, you didn't have the passcode to the defendant's phone, is that correct?
Correct.
So that device.
All right. So that's enough of Direct. We're going to jump to Cross, and pretty much at the beginning of cross, he comes out swinging. So we're going to listen and start there. Actually, before we get to cross, let's hit a couple questions. Rebecca wants to celebrate 22K in the chat. She gifted 10 Lawyer You Know memberships for that. So thank you, Rebecca, so much. And please, everybody, hit like. We make it to 20,000 likes. Never had that on any video ever. Chance, once the scene is unsecured / not secured, how can you gather more evidence? You can't prove it wasn't planted afterwards. Sure you can, because you're the cops. And when you go and you say you did that, you can put it in front of a jury. That's how it works, which is why we need trustworthy cops. So if they actually find stuff, we can get the bad guy. But I agree with you. That should be scrutinized. Sassy, do you think it would have helped if he looked at Karen and apologized for his words? I feel like it would show he felt bad, but he didn't look at her. I agree. I think that's a great idea. I didn't even think about that. I think that's great. And that's why, some consultants and some focus groups on horrible evidence, sometimes you can find some help from somebody like you. Now, what he does with Yannetti here in a minute in real time, how he feels right now, doesn't help his case. Mary Claire, I was sure earlier testimony indicated JOK was wearing a ball cap with BPD on it, not the American flag. Did anyone else hear that? I can't remember, Mary Claire. I thought it was the American flag, but I'm not positive. Liz A. Peter, do you think the defense will call a forensic meteorologist to testify about snow accumulation and melt on the days they claim to have found the taillight? I don't think so. I think they're going to hit their highest points, and I don't think that's one of their most important points. I don't think so, but I don't know. I really don't know who they're calling besides, I guess, an accident reconstructionist and an ER doctor that we heard about. Mara, hi, Peter. What you know right now, state case, yes or no? No. Crypto tax lawyer, why no fifth for Proctor? His personal attorney is a former prosecutor, shocked he didn't plead the fifth. I mean, nothing he said has really incriminated himself yet. Like, talking about people like this, you should lose your job, but you don't go to jail, unfortunately. We'll see if maybe I'm missing something, maybe I forgot something, or it slipped my mind as far as criminal activity. Maybe there will be more coming in the future. Frankie, can Karen Reed sue the police in a civil lawsuit for text alone? I think there's got to be a way. I would say yes. Yeah. Ashley said, is there a HIPAA violation within those texts? Maybe. I don't think they're worried about that right now, but that could be part of the civil claim, making fun of and talking about, violating her civil rights. I mean, yeah, I give me some time. I could find probably a million causes, not a million. I could find plenty of causes of action for her against them. I think she should, frankly. I mean, this is horrible to be treated like this. Sarah, let's just do it this way. And a lot of people are not going to like this and are going to disagree with me. I get that. Disclaimer. Even if she did this, to be presumed innocent and have people talking about you like this is inappropriate. Inappropriate. First off, there ain't no way this is second-degree murder. There ain't no way they're ever going to prove intent, in my opinion. So at best, they prove manslaughter, an accidental killing that she was drunk driving and hit and killed her boyfriend. Okay, that's the best day for the Commonwealth. And you treat people like this? It's brutal. Not to say that deserves punishment. That deserves a lot of jail time. A lot of jail time. But these cops are just despicable. Sarah, did you know that their Boston cop was banned from courtroom for assaulting Karen Reed, shoulder basher Carl Douglas? I did not know that. Run the world. Wouldn't Proctor be perjuring himself to lie about his feelings and say he was sorry? Wouldn't it be unethical if Lowry coached him to say these lies? If it's a lie, yes, you're right. If it's a lie. But he's saying he feels bad. So if he's saying he shouldn't have said them, my guess is that's in line with, I'm sorry I said them. To me, it mixes in. Solo said, he's an arse, but why are they reading his text out? It shows bias and prejudice and jumping to conclusions and potential cover-up is what they're trying to prove with these text messages. People getting him gifts, him texting his sister about interviewing these people, them all joking and making fun of her, showing his bias against her. He hates her. He calls her all sorts of names. He hates the defense attorney. So that would infer potentially that maybe he would do things to make sure she was convicted. Doesn't prove the Alberts did anything. It doesn't prove John O'Keefe was beat up. It doesn't necessarily prove any of that. Maybe some of the text with the McCabe's about getting him a gift, if you want to say that proves that or tends to prove that, okay. Minnie, judge over there deflating like a balloon. Does the prosecutor get nominated in the Commonwealth like the judge? So I don't think Lally is the district attorney or state attorney in the area, so he's not elected. He would just be hired. Leanne, but usually the district attorney or state attorney is elected, and if you elect a new one, then usually new prosecutors come with them. How did he know that medical information? Can he spread those details, sharing personal health information? So I don't think he really shared besides making fun of her for leaky poop, he didn't specifically say what her medical condition was. But I definitely think there's elements of that could be in a civil lawsuit. Playing grab ass. My little girl has progressive MS. She loves police officers. It would break her heart to hear comments like this. I wouldn't want to tell my kids about this being, and maybe that's wrong of me to not show them what the world's like. But I don't want my kids thinking this of police officers. I want them to think police officers are there to help, which sometimes they are, and unfortunately, sometimes they're not. Okay, let's listen across. This is right off the jump.
Summer of 2022, August 17th specifically, you were sitting at your desk, presumably alone at your office, at about 10 p.m. at night, going through my client's personal cell phone, correct?
Yes, sir.
As a matter of fact, you were sitting there texting with your friends.
Makes it sound as creepy as possible. You're sitting there alone in your office with Karen Reed's phone by yourself at 10 o'clock at night, right? As creepy as he can set this up.
Cell phone, correct?
Yes, sir.
As a matter of fact, you're sitting there texting with your friends and colleagues at Massachusetts State Police about you going through her personal cell phone. Is that right?
Correct, sir.
And that included Trooper DeChico. Is that right?
DeChico, yes, sir.
Trooper Fanning, Trooper Butnick, Trooper Moore, and Trooper Kotskowski.
Kakowski.
Tell me that again.
Kakowski.
Kakowski.
Yes, sir.
All right, all the consonants are silent. Fair enough. Trooper Fanning and Trooper Butnick are your supervisors.
Yes.
And you were bragging to all 5 of them that you were going through Karen Reed's cell phone about 9:45 at night.
Objection.
I'll allow it.
Is that right?
I mean, that's how you know Bev doesn't like this guy, right? Because he said you were bragging. That's objectionable. It's potentially argumentative. Bragging, define bragging. What does it mean? She sustained similar objections. I think it's a fine question. And she allowed it immediately. She didn't like this guy, I don't think. Can't blame her.
No, I wasn't bragging, sir.
How did you refer to Ms. Reed in that text exchange where you informed them that you were going through her phone?
I used regrettable language. I said going through his retarded client's phone right now.
You were shown a photograph of my colleague, Mr. Unetti, correct?
Yes.
Can I approach?
Yes.
So they take a second going through this photograph. I'm going to kind of skip ahead a little bit after the sidebar.
On the television, may I display this part briefly? Sure. Thank you. You see that, gentleman?
I do, sir.
Is that the photograph that you received?
Yes.
Is that what you referred to on direct examination with Mr. Lally about receiving a photograph from Mr. Unetti?
Correct.
And then your response was what?
I hate that man. I truly hate that man.
Actually, your response was, I'm going through his retarded client's phone right now, correct?
Yes, after the...
Jackson seems like the type of guy. A lot of lawyers are confrontational and like uncomfortable situations and like to say the hard things and listen to the just brutal silence. He wants to say him. He wants to make this officer say him over and over again to just highlight what a despicable jerk he is. So I don't really know how much sting Lally took off these because I think Jackson is fully prepared to rehash every single one of those horrible texts. Every single one of them. Amy Z, yeah, it's a good point. And it's thinking, what is the jury thinking? Because they haven't read all the other officers' personal texts, right? So why this guy? Well, it's the guy they've been highlighting all along. It's the lead case agent. Do they think this is normal? I don't know. But they got to be trying to figure out what the heck is going on with this guy and his texts.
Sir, yes.
Who's the retarded client?
I was referring to Miss Reed. Again, unprofessional language.
I'm asking who you referred to.
Miss
I know
Reed.
you've got an explanation. Who was it you were referring to as retarded?
Miss Reed.
Karen Reed, the woman sitting to my left.
Yes, sir.
The subject of your investigation as a professional, correct?
Yes, sir.
As an unbiased, objective investigator. The person
I
that you
don't think any of us can call him a professional at this point, but he's making the point for bias.
Yes, sir.
the subject of your investigation as a professional, correct?
Yes, sir.
As an unbiased, objective investigator. The person that you were investigating, you referred to your bosses as retarded, correct?
Again, poor language on my part.
Poor language is one way to put it. Completely offensive is another way to put it, right?
Objection.
That's the better way to put it, sir. Regrettable is excuse me. Regrettable is diminishing how horrible this is, frankly.
I've got to sustain that, Mr. Jackson.
After you referred to my client as retarded, then you decided to make a comment about Mr. Unetti, her lawyer, correct?
Correct.
And what did you say about Mr. Unetti again?
I hate that man. I truly hate that man.
I hate that.
That's like the fourth and fifth time we've heard it, right? So did Lally take away the sting? I know I felt horrible. I felt stung when I heard Lally say it and I heard them go through it on direct. Did you? I felt stung then and I'm feeling stung again. Now I just feel like I got stung twice. A bunch of people have said similar things to Super Jaster here. How different would this case be if the feds didn't get involved? And that's why my dad and I, the only thing I looked at prior to this case was some of that federal investigation stuff. And we talked about how unusual this is. And for them to go to trial while that's kind of open and happening. Incredibly unusual. And that's why having this much on defense and this much confidence and having the goods to this level is unusual.
That man, I truly hate him, correct?
Correct.
You didn't say I dislike him, disagree with him. You said I hate him, correct?
Correct, sir.
That's a visceral response to someone who's just doing a job, correct?
Objection.
Sustained. You can ask it differently.
Sure. Let me ask it this way. Were you upset or annoyed or pissed off that Karen Reed had gotten representation, legal representation, to represent her?
No, not at all. That's all right.
Well, let me ask you this. In August of 2022, you said you absolutely hate it, correct?
I don't know if he was absolutely. Yeah, I didn't use absolutely, sir.
You used truly, correct?
Truly, yes.
How do you feel about it now? Sitting right there.
I still don't care for him now.
I'll let it stand.
He said, I still don't care for him now. I'm pretty sure. I'll put it down to normal speed here so we can listen to the last. I think I got 10 minutes left here, so we can listen to the last 10 minutes on normal speed so we can hear it all.
Absolutely. Yeah, I didn't use absolutely, sir.
You used truly, correct?
Truly, yes.
How do you feel about it now? Sitting right there.
I still don't care for him now.
I'll let it.
Objection in between, but he said, I still don't care for him now. So that should answer some of your questions about, whether or not he really wanted to apologize to Karen Reed. Olivia, good point. And I think about this all the time. People without money, how's the system treat them? Because that's what we fight for, right? Regardless of what people think about lawyers, like what we think we fight for is everybody. Everybody. When we fight for our client, it could happen to anybody. And we're truly seeing that in today's day and age, right?
Stand.
Just listening to anything on normal speed, it makes me feel like it's dragging. My brain is messed up at this point.
What did you tell your colleagues that you were looking for as you sat at almost 10 p.m. at night on a Wednesday night, August 17th, 2022, looking through Karen Reed's phone?
I didn't tell them I was looking through anything. They knew I was going through Miss Reed's phone. I provided a inappropriate joke as an update. They knew I was going through location data, text messages, Google searches. But like I had mentioned earlier, I had to stop.
Except for Proctor, none of that really professional sounding stuff ended up in your comments to your bosses, did it?
Again, it was a poor joke.
Is that yes or no?
Did you not know?
It did not.
No,
As a
sir.
matter of fact, what did you write after you talked about going through the, quote, retarded client's phone?
Objection.
I'll allow it.
He said it, right, Lally? I know you don't like it, but he said it.
I
I don't like hearing it either. The jury doesn't like hearing it either. That's why Jackson keeps saying it. Nobody likes hearing it, but he's quoting Proctor.
no nudes so far.
No nudes so far, correct?
Correct.
When you said that to your bosses,
Yes, sir.
you were looking for naked photographs of Miss Reed on a Wednesday night as you sat in your office at 9:44 p.m., correct?
No, not correct.
Let me ask you a question. Have you ever looked for naked photos of a male suspect that you were investigating?
I don't look for naked photos in anyone's phones.
But you said
That's kind of weird because that's what you said. John said, I was trying to think outside of the box. Looking at nudes isn't illegal, especially if one has access to review KR's phone. I don't like it, but is it breaking the law? No. Well, yes, it could be breaking the law. If you are using evidence for purposes that don't have to do with the case, or if you would have taken the nude photos from her phone or sent them in the group chat, that could be potentially actionable civilly, criminally, depending on different things. You could probably try to charge him on and have to look into it a little bit more. But at this point, the fact that he's saying this just shows how unprofessional he is, to show how not credible he is and to show his character, basically. They're assassinating this guy's character and credibility. And he is the lead investigator on the case. And that's what they're doing. Sometimes it's allowed, sometimes it's not. But in this case, they're also doing it to show nobody in the police department did anything. Well, there was some objection, so I don't know if he got reprimanded, but his direct superiors did not reprimand him when he sent these texts to them. And that's showing a larger system of corruption. And that's what they're trying to show when they're talking police cover-up. That makes a lot of things relevant.
You were looking for nudes of Miss Reed,
Like I
correct?
said, Mr. Jackson, it was an inappropriate joke.
So this is a citizen. She's a woman. You were supposed to be objectively investigating. Does your text message to your colleagues at Massachusetts State Police reflect an objective investigation of a citizen?
Objection.
You can get part of that question and ask it again.
Do you believe that your text messages were reflective of an objective investigator?
Objection.
I'll allow that. Do you believe that, Trooper Proctor?
I believe poor jokes have, in unprofessional language, have no bearing on the integrity and the facts and physical evidence of this case.
It's not that they don't have any bearing on the facts and integrity. It's that they have no place in a professional investigation because it shows bias, right?
Objection.
So I have to sustain that as asked. Go ahead and ask it differently, Mr. Jackson.
You weren't so much as objectively investigating Karen Reed as objectifying her, correct?
Objection.
I'll allow that.
That was one of the questions asked before. And again, Bev's allowing it, which is interesting. And somebody asked that earlier.
Is that right?
Rephrase the question, please.
You weren't so much as objectively investigating her as objectifying her in those moments, correct?
Again, Mr. Jackson, it was a poor choice of words and a joke that I should not have texted out. But from the start of the investigation, we didn't know what we had.
And you're
Honestly, like even listening to him, especially in normal speed, it's like, I don't even believe his apology when he says it. It's like, it was an inappropriate joke. I shouldn't have said it, but we still got the right girl. Our work is still good. You know, we did everything right. That's exactly how it should have gone. There's so much evidence against her. Like, there's not a lot of sincerity in his voice. It's a hard thing to judge. I don't know how the jurors feel about it, but I mean, if this is the lead case agent, the lead one, the most intricately involved officer on this case.
Trooper Proctor, your point in saying no nudes so far to your colleagues in Massachusetts State Police was to suggest that you were looking for nudes and you'd update them when you found them, correct?
Incorrect.
Well, let me ask you a question. Did you find any nudes of
Again,
Karen Reed?
I didn't go through the photos, sir.
Did you find any nudes of Karen Reed?
I didn't go through the photos, sir.
You weren't successful in your quest.
I came across text messages from Miss Reed to another attorney on January 29th, so I had to stop looking through her phone.
And you can tell, and somebody asked this question. FKR said, so on 129, she already had text again, Eddie. I think that's exactly what Proctor wanted the jury to know. She's texting a lawyer, a criminal defense lawyer right away on January 29th. And I came across it, so I stopped. Because she knows she's guilty, because anybody that calls a criminal defense lawyer is guilty. He didn't say that part, but you know, that's what they like to infer with this stuff, or they want the jury to infer from them saying things like that. What's up, Emily? So that's why he keeps saying that.
So you got sidetracked before you could get to the naked pictures of Miss Reed. Is that what you're saying?
Sustained.
To be clear, when you sent those text messages on that group chat, those text messages included, as we said, or as you said, not one, but two of your supervisors, correct?
Correct.
Were you ever reprimanded for your conduct in sending that text message?
Objection.
So that's sustained. Do we need to go to sidebar based on what you told me earlier?
We do not.
Okay, so,
I'll ask it a different way.
okay.
Did either Trooper Fanning or Trooper Buchanan dress you down in a responsive text message in that text thread for doing something so abhorrent as looking for nudes or referring to nudes of a female suspect or subject of your investigation?
Did your supervisors tell you, you better not speak like that?
Did that ever happen?
Not that I can recall.
As a matter of fact,
No, they didn't.
in reference to,
He's still Trooper Proctor, not former Trooper Proctor. Maybe put him on leave. Like, here's the thing. If you want to act like you didn't do anything wrong and you want to act like you stand by him and all that stuff as the Commonwealth and as, you know, the PD, but it's like with these texts alone, you could be on administrative leave and maybe the jury would think, okay, you know, they're doing the right thing. So maybe it's not systemic through the whole department and things like that. There are ways you can do to at least make this look better, even if you're going to give him his job back right after trial.
one of the text messages in the same string, your boss, Yuri Buchanan, actually responded to the photo of Mr. Yannetti, didn't he?
Objection.
I'll allow it.
He did, sir.
After you received the photo, that's when you said, I'm, quote, funny, I'm going through his retarded client's phone. Is that right?
Objection.
I'll allow this, but not too many.
Sure. Is that correct? It's on the top of page
Yes, sir.
685.
That's correct.
And Yuri Buchanan liked that comment. Funny, I'm going through his retarded client's phone. Didn't he?
I see you laughed at an image here, sir. I can't tell if he,
Yeah, I mean, like, frankly, the people in the group chat, not just as bad, but not great from them either. And those are witnesses and names we've heard before as well. Gathering evidence and pieces of evidence and interviewing witnesses in this case.
liked that comment, sir.
May I approach?
Yes.
I don't know if it's just because it's faded or, yeah, my copy's faded.
Top 2685. You can use my copy if that helps.
All right. Thank you.
What do you see on the top of that page?
That it, Sergeant Buchanan liked it.
Like what?
The going through his retarded client's phone, sir.
That's Yuri. That's the guy we just heard from 2 witnesses ago. He liked it, ratifying it as the supervisor. This does not prove what happened to John O'Keefe in that yard. Okay, so don't mistake this. But to act like this is not important and not going to have an effect on the jury would be misguided and would be ignorant to think that these people who are human beings judging the credibility of witnesses, they've heard from a bunch of witnesses, they've heard this guy's name 1,000 times. This is going to be a shock to their system. Churicity said, have you been surprised about this case coming in just as a juror, no outside info? Yes. And just as a juror, these cops suck. This guy sucks. I wouldn't want him anywhere near my case or anyone I cared about's case. So how much do I hold that in Karen Reed's favor / against the Commonwealth? That's the question for the jury.
Approach?
Yes.
I'll take my copy.
There you go.
So your supervisors at Massachusetts State Police not only didn't ride you for making comments like this, encouraged it.
Objection.
Sustained.
I would have said they liked it. Not only did they not dress you down for it, they liked it because he said they liked it.
Trooper Proctor, this is your direct chain of command. Is that right? Yuri Buchanan?
Yes, sir.
Did you believe that your conduct was a misuse of your authority and power as you were going through her phone in August of 2022?
Obviously, he's going to say no to that. But ask the question. Let the jury hear it. That's what he wants the jury to think, that he was abusing his power. It's all about the question and cross.
Objection.
I'll allow it.
No, I had a warrant signed by a district clerk, Stoughton district clerk, to go through Miss Reed's phone. I don't think it was an abuse of power. I had every right to go through that phone.
Did the warrant say anything about looking for news of my client?
Objection.
Did it
No, Your,
say anything about that?
no, Your Honor.
Okay, next question.
So that would be an abuse of the power that was given to you by the court, correct?
Objection.
Sustained.
And again, he wants to say you have power to get information, to get evidence, to get discovery, not to do what you did, not to look for nudes, not to spread her medical information around, not to do everything you did with your power because you abused it, right? That's what he wants the jury to think. And Azam, everybody hit that subscribe button if you haven't already. We're on our way to 400K, which is crazy to think about. Azam also asked, can the defense use that in closing, Peter, using the vote guilty is same as voting for Proctor, maybe not in the exact verbiage. Thanks, Peter and John. Yeah, not in the exact verbiage probably, but I think they can get them to feel like this is Team Proctor over here. Do you really want to be with Team Proctor? There are ways to make that argument appropriately in closing. Bill Smith, why on earth would the defense say a week? Why not say 2 weeks and finish early? So it's all about how you want to do it. Usually I give myself an extra day or two. I would never give myself an extra week, but an extra day or two just in case something happens. Maybe they told the judge that. Maybe the judge will allow them that leeway. I think with how long the state's gone, the defense is also, they're private attorneys. And most of the time, I'll just say most of the time, good attorneys, not just private attorneys, but good attorneys, civil, criminal, whatever, do the keep it simple, stupid strategy. Get in, get out, get what you need to get in front of this jury. Don't bore them. Don't make them hate you, and move on. Prove your case, nothing more, nothing less. Eric, as being a law enforcement myself, not to justify his disrespectful texts, but we see people on their worst days on a daily basis. Dark humor is not pretty, but a way to cope with the horrors of this job. I get that to a certain extent. Like the guy, when they showed up for the guy that literally execution styled his kids, I get that. But I don't get that in this case. Honestly, it's really hard for me to find an understanding with this back and forth. Ryan, lawyer, do you think Proctor will stay employed after this? I don't think he should. Wafa, Peter, these texts were absolutely terrible. I feel bad for all the hate Lally is getting. Though he is just doing his job. What do you think? It's so hard to know what people know and what their involvement is. But if he's just doing his job and he was the guy, it's his job. They forced him to try this case and he's doing the best he can. I get it. I agree with you. I've tried not to be too hard on him. He goes way too long and goes in way too many backgrounds. Obviously, if some of this information is not true or not credible, I don't think he should put it forward. And if it was his decision to prosecute and go forward, I don't think there's anywhere near enough evidence for this. I think it was a bad call to prosecute this case. That's just me personally. But we can have a disagreement with that, and I'm not saying anything personally against Lally. Jen, these texts are horrible, but I need data, computer data from her vehicle. I want to hear how Karen hitting by him caused those wounds on his arm. Absolutely. I think that's the only shot the Commonwealth has left. Alex, I want them to be like, if you were being investigated by the Internal Affairs and everyone in Internal Affairs was laughing about how much they hate you, still feel there's no bias. Still feel like, yeah, this jerk and calling him all these names, this guy was so pompous and he thought that and he abused his discretion before any decisions were made. I wonder how he would feel. Gingy Probs, happy Monday. In your opinion, is there a chance the court grants a defense motion for judgment after they complete their case? Is there a chance the court grants a defense motion for judgment after they complete their case? I would be shocked. There's always a chance, but I would be shocked. Nikki, anyone else think he went straight to the bar with his buddies and was laughing about this? It would be within his character, but I don't know. I obviously don't know. I hope he didn't. Michelle G, I'm behind a bit regarding the taillight cracked with a piece missing. When Ms. Puzzle Lady put together the taillight, she had all the pieces except a piece. What do you think? Maybe that's the clear piece that was in John O'Keefe's yard. I'm assuming that's what you want me to say. And I get it. And that's a small piece. That's just one piece of the reasonable doubt in this case. There's so much reasonable doubt in this case. With the investigation, with Proctor, with the taillight, with the collection of evidence, with the securing of the scene, statements she may or may not have made. Kay's Eddie, J.O.'s mom was laughing at some of the text. I feel terrible for them, but do you think they see how bad all this is through their grief and anger? I don't know. I did not see that, so I can't comment on that. T. Shaw, lawyer, any idea if Proctor's on the Brady list? I don't know. I didn't see the Brady list, so I don't know what was on there. Shaylin, today was one heck of a day for court discussed between Proctor in this case and YSL judge having an ex parte convo with the state and a witness and then jailing the defense attorney. Not a good day for justice. I agree. And we'll be breaking that down soon. Chris, Amanda's law prohibits first responders to take photos of crime scenes and share them. A cop shared pictures of a young murder victim at a youth football game. I wonder if this will create another iteration of the law. Yeah, it's always hard to tell what's going to come from a case like this, but usually things do. All right, let's listen to some more of Cross here. We got a couple minutes left.
Trooper Proctor, you'd agree that the hallmark of any good investigation, as you've been taught and others in Massachusetts State Police have been taught, is that the investigation and the investigator have to be fair. They have to be impartial. Would you agree with that?
Yes, sir.
Meaning that the investigation has to be free of conflicts, right?
Yes, sir.
Those are great questions because he has to agree, right? He has to agree. And that's their whole case, that they don't think it is.
The investigator has to be free of conflicts, right?
Yes.
The investigation has to be free of bias. Is that right?
Correct.
You can't be biased against the person that you're investigating. That would compromise the entire thing, wouldn't it?
Yes.
Basically, you follow the evidence. You're supposed to follow the evidence wherever it takes you, right?
Correct.
Good or bad, top to bottom, just follow the evidence and report it back. That's how an investigation is supposed to be run, isn't it?
Yes, sir.
And these are things that you learn early on at Massachusetts State Police Academy and then in your detective training. Isn't that right?
It is.
Literally, it's part of an oath that you took at the academy that you will, quote, faithfully and impartially discharge and perform all of the duties incumbent on you as a Massachusetts State Police trooper, right?
Yes, sir.
You swore.
Anytime you can use the oath and quote it when you've got an officer doing things that are absolutely unbecoming of an officer, it's a very artful and skillful way to cross-examine an officer in a situation like this.
Swore that oath,
I did.
What do you say?
right?
Yes, sir.
You swore that oath.
I did.
When you start an investigation, everybody in that investigation should be treated exactly the same. Don't you believe that's true?
Correct.
Everybody, have you ever heard the phrase, everybody's a suspect until they're not? Right?
Objection.
Sustained.
It's especially important early in an investigation before all of the facts are known that the investigator is not compromised by bias, prejudice, right?
Correct.
Most important early in the investigation, because that's when the most things are up in the air. There's the cloud, the fog of not knowing exactly what the truth is, right?
Objection.
Sustained.
In other words, Trooper Proctor, you don't get to pick a suspect and then try to find evidence to support your choice, right?
Correct.
But in this case, it's exactly what you did, isn't it?
Absolutely not.
All right, Mr. Jackson, why don't we?
And that's kind of what makes it relevant, and that's where they're going. Now, it sounded like he was winding up. Maybe he knew it was coming to the end of the day, but I would assume there's a lot more. Let's hear how the judge kind of wraps it here.
End for today.
This
Okay.
is as good a place as any. Thank you.
Okay.
All right, so folks, we're off tomorrow. Those same 3 cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, read anything about the case, please disregard it and let us know. We'll see you Wednesday morning. So Wednesday, Thursday, Friday, right now, it's anticipated will be full days of testimony shortly.
Anticipated right now to be full days. We went 2 hours tonight because there's nothing tomorrow on Karen Reed. Please make sure all you guys subscribe that are here. Let me know if you're new from this video. This is, I think, one of the biggest chats we've literally ever had on the channel. So chances are there's some new people here. If you just subscribed from this case or from this live, please let me know in the chat. I'd love to meet you, see your name, and start looking out for some of the questions and comments that you have. Mo, is it possible that he's being forced to testify honestly by the feds, aka the reprimanded objection, proffer possibly? I don't know the answer to this. We didn't see what happened at the sidebar. I mean, forced to testify honestly is kind of always right for a cop. You take the oath, but I don't know if there's anything additional because of what's going on with the feds. Emma, Peter, have you ever encountered a witness like this, a police officer that is a tool to this degree in this manner? If so, how'd you handle it? I always do it with more of a try to be extra nice and make them look like such a jerk by reading out what they do again. I usually try not to be sarcastic, even though that's sometimes my natural inclination. Sometimes I am. Get forceful with them if they need it. But I honestly, I've never had a situation where I've gotten a cop's personal texts in a case. We had one case where we got some personal stuff on a cop, and that's the federal case that ended up getting literally thrown out by the judge because it was so bad. SJ, do you believe if they will investigate Proctor's work history, further federal probe? Maybe, but a lot of these things are, from Proctor's point of view, specific to Karen Reed. So I don't know how much they're going to, open Pandora's box. Consistent. I asked earlier in the case, why did the judge force this case to go forward? They obviously don't have the evidence to prove their theory. Well, if they lose, the state can't appeal for that reason. So maybe it was something good for the defense. I know nobody would believe that with this judge, but it's possible. Cast the sass. But the defense didn't want to go forward either. From the red solo cups at Canton PD to the disgusting text messages of MSP investigators, this case is so full of despicable behavior that I'm 100% not guilty. I do think it's difficult to overcome. Rashenda, now I can see why he wasn't called early on. They would have lost the jury right away. This guy destroyed what little credit the prosecution had. I definitely think it was good to not call him early. All right, I got to run. I'm going to try to hit a couple more on the way out. This super chat's for Mr. John Nizer from behind the scenes. Hi, and thank you for your time too. John, you need to come out more often, sir. I think he's going to come out in the next Members Only Live again because we have something funny planned. John O says John N for president. Lady Los Angeles said, I so waited for your insight. Thanks. Hopefully it didn't disappoint. Hopefully you guys learned something. Hopefully you had an interactive experience here with questions, answers, comments, everything. You guys add so much to this content. FKR said, I own an auto body shop, a licensed auto damage appraiser in Massachusetts. When a TL hits an object, a car, the tail light can crack. If impact hard enough, it can break a piece will fall into the cavity of the taillight. Yeah, I don't know how it shatters out like that, right? That's a good point. It's a good point from an expert. Welcome, Jules, and all the new members. Also, let me know if you guys joined and you're a new member as well. We've got a June Members Only Live coming up. You guys are awesome. This is crazy. This is a long one for me. I usually try to keep it to an hour. This was nowhere near. Usually I do a better job. This trial has gone a little bit longer. I see a bunch of people saying they're new to the channel. That's awesome. Welcome, everybody. We love disagreement and discussion in the chat. We love to do it respectfully and treat each other like human beings, unlike Mr. Proctor treated Karen Reed and others in this situation. But that's all we got. Till next time, we will have a video tomorrow, probably on the YSL case. That's crazy too. But for this one and for tonight, for Peter Tragos, for John Nizer, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.